Uh, well, did you want to wait? All right, good evening, everybody. We're going to go ahead and start the December 18th, 2025 Zoning Board of Appeals meeting for the City of South Fulton. Would staff call the roll for us, please?
Mr. Johnson,
Present.
Dr. Blackshear,
Present.
Ms. Patterson,
Present.
Mr. Mathis,
Present.
Mr. O'Donnell,
Present.
Mrs. Plies Ferde, Mrs. Jerome,
Present.
Mrs. Evans. We have a quorum.
All right, we have a quorum. Second, has everybody had a chance to review the minutes of last month's meeting? If so, I'll take a motion. If you want time to look it over, please do so.
Make a motion to accept the minutes.
I second it.
It's been properly moved and seconded to accept the minutes of last month's meeting. All in favor say aye.
Aye. Aye.
Any opposed, nay. Hearing none, the minutes of last month's meeting are accepted into the record. All right, we have one case tonight. Looks like a popular case. That is going to be an administrative decision regarding emblem at Sandtown plot and land disturbance permit. Okay. All right, we're going to have public comments. There are 10 minutes reserved for those speaking in favor of the case and 10 minutes in opposition. Everyone comes to the podium, states their name and address, and if you are a City of South Fulton resident. Do we have cards, staff, for anybody speaking?
Yes, we have 4 cards in favor, and that is Hakeem Hilliard, Joe Siegelman, Taylor Harper, and Ray Crocker.
Okay. Is there a case number here? I'm not seeing the case number here. I want to call it in officially.
I haven't seen the case number.
I don't believe there is one.
No case number, okay. All right, so the first case, then I'll just read it as is an appeal to the Zoning Board of Appeals per section 808-19 for administrative decision regarding emblem at Sandtown plat and land disturbance permit. Parcel IDs 14F0109 LL1137. Second parcel 14F0109 LL0311. And a third parcel 14F0108 LL0205. Is the applicant here? All right, please step to the podium and state your name. Hang on one second. Was there from the city that we wanted before we got started with the petitioner?
Assistant City Attorney Carlos Alexander, beg the deference of the board. This is our first time doing this type of a hearing, so I would ask that we extend the time from 10 minutes to 15 minutes for the for and the against, and allow Mr. Hilliard to have the 15, but also to incorporate any speakers that are speaking on his behalf. I don't know if there are any members of the public. I know that he has. I'm sorry. I know that Attorney Hilliard has his team here, but I don't know if there are any members of the public who are. So if the 15 minutes could be extended for Attorney Hilliard's side as well as any members of the public that are speaking on his behalf, and then also 15 minutes for the city side and any members of the public that are speaking on behalf of the city, I would ask the court, the board's indulgence for that.
Wait one. I'll take a motion to alter the rules for this particular case and extend the talking time to 15 minutes as opposed to 10 minutes.
I'll make a motion to extend the time.
I'll second it.
And properly moved and second to extend the talking time from 10 minutes as normal to 15 minutes. All in favor, say aye.
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 Any opposed, nay? Hearing none, you guys have 15 minutes each.
Okay, and we'll start with Attorney Hilliard.
Mr. Chair, just as another housekeeping matter, we have a binder of information that a booklet we have to give out to each of you all. We want to make sure that it's included as a part of the official record in this matter. It is the same documentation that we submitted when we filed the appeal.
Neighborhood presentations are in here that were not actually.
There's one additional document in there, and we'll discuss that when we give that to you. But because this hearing is on the record, we wanted to make sure we officially produce these documents to you for your review. And we won't. Any objections to that? No. Okay. I've got my real lawyer here helping me do it the right way. Well, thank you very much, Mr. Chairman, members of the board. Good evening. My name is Hakeem Hilliard with Shillivitz Grubman Law Firm, 1834 Independence Square, Atlanta, Georgia, 30338. I'm here this evening on behalf of Cortera Development Company in the appeal involving what some of you know as the emblem at Sandtown Development. For more than 30 years, I've worked in zoning and land use, advising planning departments and representing applicants before cities and counties across the state of Georgia. In my career as a city attorney in the city of Atlanta, I served as counsel to its Board of Zoning Adjustment when that body heard appeals very much like this one, an identical quasi-judicial body with the same charge you are assigned tonight. I've advised directors in roles just like Mr. McClendon's. I've stood where Cortera stands today, asking boards like this one to hold government to its own written word. As a zoning wonk who cares deeply about how this system works, this decision saddens me because it undermines the basic promise that if you follow the rules and rely on the city's written approvals, the city will stand behind them. Let me start with Cortera, what Cortera was trying to do and what it was relying on. In early 2024, before it committed to invest in South Fulton, Cortera came to the city to understand exactly what it was allowed to do on this property. This is not a request for a new zoning. There's an existing zoning case on this property from 2001, before the city of South Fulton was created. It was Fulton County governed this area. That zoning expressly allowed multifamily use and left remaining entitlement for approximately 200 additional multifamily units on this site. This is the controlling zoning on this property, and the city does not dispute that multifamily is allowed here and that there were remaining units to be developed. Cortera came to the city to confirm exactly that it could develop those 200 additional units within the remaining multifamily entitlements already allowed under the 2001 zoning, and that there was no separate binding site or concept plan that limited that zoning in a way that the code actually enforced. Before investing heavily, Cortera asked the director and his team in substance, under the existing zoning, are we entitled to build these additional units? And is there any site or concept plan that legally prevents us from doing this? The director reviewed the record and on July 3rd, 2024, issued a written confirmation letter saying, yes, under the 2001 zoning, this multifamily project, including the additional units, is permitted without identifying any operative site or concept plan that would block it. Later, Taylor Harper with Cortera specifically asked the city staff about any site-specific review requirement and was told that there was none, and that applied to restrict this project. That written confirmation is what Cortera relied on, and it is then followed the city's process, submitting plans and civil plans, responding to the staff comments, and working through review cycles for more than a year, with staff ultimately saying that the plat was ready for the consent agenda, encouraging Cortera to keep going. With me tonight is my colleague Joseph Siegelman, co-counsel for Cortera, and two members of the Cortera team who have been directly engaged with the city on this project, Mr. Ray Crocker, Cortera's managing director for the Southeast, and Mr. Taylor Harper, Cortera's director of development for the Southeast. They have provided detailed affidavits documenting the meetings with the city and the director's confirmation and the SAGE's online system entries and the sequence of approvals and the later denial. What happened instead of the city standing behind that written confirmation is this. After more than a year of approvals and assurances, the city manufactured a new argument that that an old concept plan should now be read to require that this project be designed in a way that contradicts the very approvals the city itself had been giving over the past year. Let me put that what it means in simple terms. A family receives an inheritance from their parents. Before they spend it to build a house, they go to the city hall and ask the director in writing, "Are we allowed to build this here?" The director reviews the code and sends back a written confirmation, yes. Only then do they commit their money. Over the next year, they build, inspectors come out. Each time there is a correction, the inspector says, "Fix this and keep going." The city's message is consistent, you are approved. Then, near the end, someone else inside City Hall, not the director without his legal authority, persuades staff to flip the status in the computer from approved to denied. The rules have not changed. The director has not sent a new letter, yet the approval they relied on with their life savings is simply taken back. Everyone in this room understands that is wrong. That is what happened to Cortera. Cortera did exactly what a responsible applicant is supposed to do. It went straight to the city's director, received that formal written zoning confirmation, and then spent more than a year submitting plats and civil plans, responding to every technical comment, and working through every review cycle the city required. Staff told Cortera that the plat was ready for the consent agenda and repeatedly encouraged it to keep going. Cortera invested roughly $900,000 in fees, engineering, and carrying costs on the strength of those approvals. And then after all that, the status was flipped from approval to denial. Even after the reversal, Cortera tried repeatedly to meet with the director and understand what had changed. Those efforts were refused. There is still no written explanation from him of what rule Cortera violated. At this point, it is important to be candid about what happened. This plat was pulled from the council consent agenda twice. The first time we understood it was to allow for a meeting with neighbors. The second time there was no explanation. When we asked the director to discuss what had changed, we were met with silence. We eventually spoke with Matthew Williams, the city's planning and zoning administrator, who told us we needed to start the zoning process over, a process that had already been completed and approved. Cortera is troubled by what staff shared about how this decision was reached, including the role of the direction from the district council member, but the legal violation that warrants reversal sits squarely at staff's feet. Staff and the director took lawful written zoning approval relied upon for more than a year and reversed it without codified basis, without any written findings from the official who issued the approval, and without any coherent explanation for what provision of the ordinance Cortera supposedly violated. Cortera is understandably concerned that when asked to justify this reversal, the professionals charged with preserving the integrity of the rules that govern development in the city had no reasonable code-based explanation to offer. That is not a lawful correction of an error. It is an unlawful surrender of a vested approval. And it is exactly the kind of arbitrary action your ordinance requires the board to undo. Your ordinance, section 5-6009, sets out a simple but important standard. An appeal must be sustained if you find either that the administrative official's action was based on an erroneous finding of material fact or that the administrative official acted in an arbitrary manner. Both prongs apply here. The reversal rests on an erroneous premise that the concept plan that was never treated as binding codified a limit on the 2001 zoning approvals, followed by a status change ordered and defended by people other than the director with no written findings from him and no willingness to sit down with the applicant to explain what rule had been violated. When an applicant gets a written approval from the director, spends over a year following staff's instruction, and invests $900,000 in reliance on that, those are vested rights your board should protect. We have preserved all constitutional objections, due process, equal protection takings in our writings and our filing. You do not need to decide those tonight. What you do need to decide is whether this internal override that the director's decision after a year of reliance is erroneous and arbitrary and under your own ordinance. You may hear the city's outside counsel argue tonight, we just corrected the mistake. But if that were true, the director would have issued a new letter explaining the error. He hasn't. You may hear the city attorney say the concept plan is required the 2021 age-restricted project to go through a zoning. That is true, but that was a change of use. Here we are staying within the same multifamily use of the 2001 zoning, what this 2001 zoning allows. Unless there's been an unwritten decision from the director that postdates our appeal, that zoning change is not changed. And you may also hear, you should defer to staff. Deference makes sense when staff applies clear rules consistently. It does not make sense when a director's written approval and a year of staff approvals are undone by someone else with no written explanation. As I close this preliminary comment, let me address one comment that captures the problem better than any legal brief. Matthew Williams told us, we need to start over and go through the zoning process. And when we asked how the city could change the process after all this time, he said, we have the right to change our mind. We obviously disagree with that. The city does not get to change its mind about vested approvals without clear error and a formal written correction by the official who made the decision. But Mr. Williams is the only person in the city who took time to explain this, and he has never shied away from a conversation. He's a good man walking around with bad facts. The law does not allow what those bad facts describe. If there truly had been a clear error, the director himself would have made that decision in writing with a straightforward communication to Cortera. None of that has happened here. The affidavits of Ray Crocker and Taylor Harper document all of this. The director's July 3rd, 2024 zoning confirmation, the pre-development meetings, the SAGE's entries showing approval and consent agenda readiness, and then the unexplained switch to denial without any written directive from the director. That is the record you have before you. We are here because Cortera relied on the city's written assurances and paid a steep price, about $900,000. But this is bigger than Cortera. Every credible builder and investor who hears this story will ask, if a director's written approval, confirmed over a year of staff reviews, can be undone by someone else inside City Hall without a word from the director, how can I safely invest in South Fulton? And here's what saddens me most. This kind of behavior has already been called out by the courts. South Fulton has already been cautioned about pulling plat off an agenda, for political and ad hoc reasons. The same pattern is repeating itself. The city has been warned not to do this, yet we are back here again. You are volunteers on this board because you care about South Fulton. You want this city to be seen as fair, predictable, and governed by its ordinances, not by informal influence inside the building by after the fact we change our mind explanations. The only way to protect this is to insist that when the city speaks it in writing through its director, it either stands by that decision or has that same official openly and formally explain why it's changed. That hasn't happened here. What cannot be acceptable is what happened here. A silent override of the director's written approval, defended only by a shifting concept plan theory and an informal claim that we have the right to change our mind after an applicant did exactly what the city told it to do. Under your ordinance and under basic fairness that everyone in this room understands, that is both erroneous and arbitrary. Your code gives you the authority and respectfully the responsibility to say so. On behalf of Cortera and on behalf of every future applicant who needs to be able to trust the city's word, we ask you to reverse this denial and restore the approvals that the director and the staff gave Cortera and had every right to rely upon. We'll reserve our little remaining time for any rebuttal that we might have, and we're obviously available here to answer any questions you might have about our appeal that we haven't answered in this presentation.
All right, thank you, Attorney Hilliard. Is the city ready?
Good evening. My name is Paul Mitchell. I'm an attorney at the law firm of Freeman, Mathis, and Gary, and I represent the city of South Fulton. I have a PowerPoint presentation that I'd like to refer to. Before I get started, though, I did, similar to Quartera's counsel, submit all the written materials. I did that last month via a link. I have hard copies as well, but just to make sure that everything is in the that's in the record. I don't have anything to add from the electronic submission from last month. So if we could look at the next slide. First, I want to talk about what your responsibility is here this evening. So you sit as an appellate body to review actions taken by the city of South Fulton. And in this case, it's actions taken by its director and staff members. I'm going to refer to the highlighted portion. It says, an appeal shall be sustained only upon, in other words, you should grant Quartera's appeal only if there's an express finding by the board that the administrative official's action was based on an erroneous finding of a material fact, or that the administrative official acted in an arbitrary manner. So those are the two things that you're looking for this evening. You're looking to see, is there an erroneous finding of material fact, or is there an official who's acting in an arbitrary manner? If there's not, then you should affirm the actions taken by the city. If we could see the next slide, please. This really all focuses on a letter that Director McClendon wrote to Quartera on July 3rd, 2024. This record is in the materials that have been provided to you, but I'm going to highlight, and you see it's a one-page letter. You'll see that this letter is written in response to questions from Quartera. And now there are two key parts of this letter. Again, there aren't too many parts to it, but I'm just going to highlight two key parts. If we could look at the next slide, please. So this is a couple of paragraphs down, and I think this is really the crux of the issue from Quartera's perspective. Certainly, if on rebuttal, if they want to disagree with that, they may. But I want to focus on this, and then I want to focus on the next paragraph. So this part of the letter. This is Director McClendon writing in response to questions that Quartera has about a property that was zoned in 2001, a property that has a site plan that we're just about to look at. So this is what Director McClendon said. We have had the opportunity to fully examine your request and confirm herein that the approved zoning, so the approved zoning is that 2001 zoning, the approved zoning allows for the development to a total of 550 multifamily units in the northwest quadrant of the subject property. That 350 multifamily units have been developed, and there remains the right to develop 200 multifamily units in the northwest quadrant. Now, I want to go ahead and point out that there is something in this paragraph. There's something that's very accurate, and there's something that's not. The very accurate part is that 2001 zoning did allow for 550 apartments, and there have subsequently been 350 apartments developed. So if the original site plan, if the original zoning was built the way that it was planned, there could be 200 more apartments. That's accurate. The somewhat confusing part here is that it refers to northwest quadrant. As you'll see in a second when we look at the site plan, there isn't really a northwest quadrant. I mean, if you think of the phrase in its most basic sense, a quadrant is 1/4 of something. The northwest part, you would imagine there's a northwest, a northeast, a southwest, a southeast. But when you see how this property is set up, you'll see that there is no northwest quadrant. And so the confusing part here is, one, the letter refers to northwest quadrant, and in fairness to Quartera, the property that they're concerned about is the northwesternmost part of this property. So it's understandable how the misunderstanding is understandable. But now if we can look at the next paragraph. Director McClendon continues in his letter. To make a record of this decision, we will include your 5/2024 letter. So again, this letter is in response to a request from Quartera. The associated zoning records associated with the subject property, and that's all in the record. And I have it There's a lot. This was zoned in 2001 in Fulton County. It's a thick file. They had it. They were aware of it. So the associated zoning records associated with the subject property and this confirmation in the zoning file related to the subject property. Thereafter, subject to the presentation of a site plan with 200 multifamily units to the Department of Community Development, as well as demonstrated compliance with all other conditions of zoning associated with the subject property, our office will confirm the subject zoning requirements have been satisfied and the proposed development can proceed immediately to permitting. Obviously, I want to highlight the highlighted part. It was always clear from the director that Quarterra was going to have to demonstrate compliance with all of the requirements of the zoning. If we can see the next slide, please. So, this letter was issued on July 3rd, 2024, and then the event that triggered the appeal occurred on September 3rd, 2025. So now we're going to fast forward just a little bit over a year, and during this time that there have been reviews by staff, and there's been a lot of back and forth, and there has been reviews by different departments within the city. There's by fire, planning, drainage, hydrology, erosion control, wastewater, landscape, traffic review. Different departments will review this, but importantly here, the planning department reviewed it, and this is kind of where we had our snag, was that there had been discussions after that first letter about, okay, does Quarterra have the right product? What you're showing us are these townhouses or are they apartments? How does this fit? And so that there was a lot of subsequent conversation. But then it becomes obvious to the city that, whoa, we're looking at the wrong thing. We're missing the most important thing here, and that is that there's a 2001 site plan that shows exactly what's supposed to be here. And so if you want to build something other than what the 2001 plan showed, you just simply have to file an application to rezone the property. This site plan, this zoning category for this property is site plan specific. So in other words, if you want the right to build what's on the site plan, you have to show up with a permit that shows that you're building what's on the site plan. Anything else, you need to ask for permission. You need to ask for a rezoning of that property. So to quickly note the highlighted portion here. So this comes from a staff email. So under the appeal filed by Quarterra, this is the thing that's highlighted. This is what you're deciding was this arbitrary or was this erroneous? So staff member Karen Tomini wrote, this development does not match what was approved in the site plan for zoning petition 2001 Z0079. That's that Fulton County zoning from 2001. The zoning case has this area designated as Pod F. We'll look at that in a second, which is a town center that contains community services, commercial components, and residential components that contain loft apartments, townhomes, and an assisted living facility. So again, you sit here tonight as an appellate body to see whether or not Quarterra is correct. And what they are insisting is that this staff member, Ms. Tomini, was erroneous, she was factually erroneous, or she acted arbitrarily. Well, what did she do? This is what she did. She wrote, her findings are right here, and so what happened, excuse me. So then the event that happened is that in the city's online portal for managing files and such, where you have the different departments who review and say, yes, green light, red light, planning department changed from green light to red light. Because they said, well, actually, this doesn't fit the 2001 site plan. So if we can look at the next slide, please. This is the 2001 site plan. So if you look at it, you can see it's kind of like an L laying on its side. As I mentioned before, if you're trying to find the northwest quadrant, Well, there's nothing in the northeast, so again, I would say that saying that there's a northwest quadrant is a little bit confusing. But I'll absolutely concede that we are talking about the northwesternmost part of this property. So if you look up there in that upper left-hand corner, that's what we're talking about, okay? Now, it might be kind of hard to see, that again, this is in your materials. It might be kind of hard to see from where you're at, but you don't even have to look too close to see that the plan that was submitted is completely different. But when you look at this Pod F, it has a mixture of uses. Again, it has community center, has assisted living, has apartments, has a mixture of uses. Okay, so this is the site plan that was approved in 2001. The only thing that anyone has a right to develop is what's in the site plan, unless they ask for a rezoning. And guess what? Someone did that in 2004. And in 2004, a lot of this was rezoned, but guess what wasn't rezoned? Pod F, this part in the northwest corner. There's no dispute that the last zoning decision on this property is this 2001, or the last site plan for this property is this 2001 site plan. In 2004, when Fulton County revised this site plan, it specifically said that Pod F stays the same. So this is the one we look at. So if we can look at the next slide, please. All right, so now we just kind of highlighted a little bit more what we're talking about. This is that Pod F. So again, it's a city center design. If Quarterra had submitted a land disturbance permit, an application for the land disturbance permit to build this, then they absolutely would have had a right to receive that permit as long as they checked all the other boxes. There's a lot of technical review that happens. But as far as from a planning perspective, all they had to do was submit this site plan or file an application to rezone so they can get a new site plan. If we can look at the next slide, this is what Quarterra submitted. It's 200 multifamily units. Again, if this is what they want to build, they need to submit a rezoning application. And then that rezoning application will be heard by the city. And if it's approved, it's approved, and they can go forward with it. But until they submit a rezoning application, they do not have a right to build what's shown in this plan. So again, think back to Ms. Homany's, her email that said, actually, we just looked and we saw this 2001 site plan. 2001 site plan shows community center, assisted living, some apartments, this mixture of uses, and what you've shown doesn't have that. So that's the whole problem here. We're not taking anyone's property away from them. We're not saying that they can't build. We're saying you can either build what's been approved or you can ask for approval to build something different. That's it. If we can see the next slide, please. So what I did in these last couple slides, and I'll be quick, is just highlighted some of the legal principles here. I absolutely concur with Attorney Hilliard's, with his sentiments. We want to do what's right. We want to do what's fair. And doing what's right and doing what's fair is following the law. And the law in Georgia is this, and I just highlighted a couple of cases. You don't get a permit if you're not entitled to it. You don't get a permit for an illegal use. In other words, if there's something that's not allowed, even if someone mistakenly issues that permit, you don't get to run with that permit and say, hey, you gave it to me, your fault, now I get to go and build this. So even if the Quarterra can point to a mistake that was made, whether it was by Director McClendon, Ms. Homany, or anyone else, the fact is the Georgia courts have recognized that that does not give you the right to build something you're not allowed to build. So just the highlighted language here, a permit for an illegal use is void, vests no property rights. Next slide, please. If a permit's issued by a governing body in violation of an ordinance, in this case the zoning ordinance, even if under a mistake of fact, it is void. Next slide, please. And then this is just one more case about vested rights. And again, the rule in zoning law is if a permit is given to you that shouldn't have been given to you, that doesn't give you the right to use that permit. In this case, no permit was ever given. It was simply the letter and then the later correction that was in Ms. Homany's email. Thank you so much for your time.
How much time does Attorney Hill, you have left.
He has 1 minute and 45 seconds.
Okay.
Thank you, Mr. Chair. I'll be very brief. I appreciate counsel for the city's arguments, but there's a fundamental flaw in his argument, a factual flaw. He keeps referring to this site plan. If the site plan were site plan specific, if this zoning from 2001 were site plan specific, we would have had a different conversation, but it wasn't. It says in the zoning ordinance from 2001 specifically, said site plan is conceptual only, and only must meet and exceed the requirements of the zoning resolution. That's a fundamental material difference in the conclusion you reach based on what counsel for the city said. If it's site plan specific, you have to build to that site plan. If it says conceptual only, it's conceptual only. It doesn't even say concept plan substantially in accordance with this plan. When I do rezoning applications, I have a site plan and I have to meet it to the T. And you all have reviewed variances requests, you see where the buildings are. If there's a site plan associated with it, you have to meet the site plan. That is not what this zoning said. And because of that, you can throw out all of the arguments related to that, because it is a fundamental difference in interpretation of the code when you look at it the way that the ordinance said it says it. The other issue is, I said about the site plan, and we talked about how this decision was made and that there was no vested rights here. This is not just one decision. This letter was not the only time we talked about this. After we talked about this, Mr. Crocker and Mr. Harper, who have expansive affidavits that detail every communication with city staff, multiple times they met with them, and multiple times, because they had to approve the zoning, each time that happened, they acknowledged that the zoning that we had was approved. So this wasn't just looking at one letter that was a short letter. They reviewed this request and approved it multiple times through the process. I know my time is up and I want to be respectful, but we hope we have an opportunity to answer more questions about this.
Okay, certainly. We've got a pretty packed audience. Were there any cards filled out for comments?
There were 2 against cards.
Okay. You want to call the first?
The first card is for Lolita Jackson.
Please step to the podium and state your name and your address, and tell us if you are a city of South Fulton. Hang on one second.
Can we establish how much time?
Yes. Yep, they only had, against only had 4 seconds left.
Against only has 4. So they're riding on the city time. The citizens who came in to talk against, they're stuck with the city's 15 minutes that they've already used?
I'd like to make a motion if it all passes.
Hang on one second, we gotta get clearly.
Unless y'all make a motion to give more time,
Okay.
Absolutely.
both sides.
Hang on one second. Mr. O'Donnell, you want to?
I'd like to make a motion that we suspend all time requirements tonight. I think this is really important that we hear all sides of the argument. I've got an entire binder here that was given to me.
Well, actually, I was getting ready to take a 5-minute recess for the board to be able to go through this packet, because you all have given us some significant documents here that I want to at least give the board 5 minutes to be able to go through. As it relates to Mr. O'Donnell's,
I'll second that motion to suspend time limit so they could speak.
okay, so we have a motion on the floor to suspend our standard. Hang on one second, city attorney, you have something to offer?
Before you vote on this motion, I would like to say that, if we suspend all time limits, we'll be here all night.
Yeah, I wasn't going down that road.
But if you extend the time to a time certain,
Yeah,
that might be more minimal, but however you extend the time, it has to be extended for both
Yes.
sides.
yeah, of course.
It's understood.
Clean up your motion a little bit, because we don't want to be here all night. Mr. O'Donnell.
I'll pull my motion.
I'd like to make a motion that we extend at least 15 more minutes beyond the set time limit for each side.
Okay, there's a motion on the floor.
Second.
All right, it's been properly moved and second to give each side an additional 15 minutes in lieu of the material that we have in front of us to review. All in favor, aye?
Aye.
Any opposed, nay? Hearing none, we're going to extend the time for 15 minutes for both sides to do their presentation. But right now, we're going to take a 5-minute recess to allow the board to kind of go through some of the information we've been presented with.
Is there an extra binder for our representative in District 5, Ms. House Verde? Thank you so much.
We're at recess. Yep, that's what Go ahead and start back up. I see we've got our two board members here. Y'all sign the roll? Okay, good, good. Good to see y'all.
Could I note something before we reconvene?
No, let us reconvene first, if you don't mind. Okay. All right, we're gonna go ahead and reconvene the December 18th, 2025 meeting of the zoning boards of appeal for the city of South Fulton. And I believe we were on citizens' comments, and you had a card.
Yes, we have two against cards.
Okay. Call the first one, and please step to the podium and state your name and address, and if you are a city of South Fulton resident.
Good evening. My name is Lolita Browning Jackson. I live at 5493 Stone Cove Drive in the Sandtown Center subdivision in the city of South Fulton. And I am here to oppose the zoning appeal for Emblem at Sandtown. This appeal asks the community to accept a development that does not align with the existing neighborhood character or the long-term interests of the Sandtown residents. We do not want any more apartments. Zoning exists, of course, to protect communities from overdevelopment, strain on the infrastructure, and projects that move forward without meaningful community support. The Sandtown Center residents, those of us who actually live in this community, deserve development that is transparent, appropriately scaled, and rooted in the needs of its current residents, not exceptions that benefit developers at the expense of us, those who live there, who actually live in the neighborhood. So approving this appeal would set a troubling precedent and further erode trust between residents and decision makers. So I urge you to deny this appeal and require any further proposal to fully comply with the standards of what it's for. And also to have genuine community engagement. Ask us for what we want outside of our homes. Thank you.
And the next card is for Donald, Mr. Donald Barnes.
Step to the podium, state your name and address, and tell us if you are a City of South Fulton resident.
Thank you. Good evening, everyone. I am Donald Barnes. I live at 5373 Stone Cove Drive, Southwest, City of South Fulton. I am the Homeowners Association President for the Sandtown Community Development, a property that has 323 homes. I am speaking on behalf of the residents of 323 homes in our community. We are wholeheartedly against this development. It goes against what we have been protecting, what we have been building, what we have been staking our finances into for the past 20 years. Our development is 20 years old. We do not need rental homes, nonetheless rental apartments. We have no issues with Quarterra. If they want to come in and build homes, single-family homes, fine. Rental properties, rental homes, doesn't make sense to us. We want to protect our neighborhood. We want to protect our home values. We want to protect what we're doing, what we're building in our community. If there are other homeowners in here who could speak, but they would be saying the same thing. So the two of us are saying what everybody else is saying who we're representing here tonight. We don't want rental homes. Imagine a rental home property being built next to your home. How would you feel? That's how we feel. Please, on behalf of the Sandtown community, on behalf of the 323 homeowners in that community, please honor our request by denying their request of building rental homes in our community. Thank you.
Does the city have anything else with your remaining 15 minutes? Because each side got an additional 15 minutes. Or would you like to defer and let them go first?
I'd like to defer that, but if I could just say that I do have a hard copy of the PowerPoint presentation, and I'll submit that as part of the record.
Okay.
Just as a matter of
Step to the podium, please.
Thank you, Joe Siegelman, on behalf of Quarterra. Just as a matter of general housekeeping, as counsel for the city was saying, I believe they have hard copies. The binders in front of you are respective hard copies. I'm not sure if a motion needs to be had to formally accept their copies, our copies, into the record, but mutually, I think you can speak for yourself. I have no objection to that occurring if it's helpful or needed to make these copies officially part of the record. Thank you.
And there's no objection from the city.
Okay, thank you.
I'll be very brief. Again, it's Hakeem Hilliard on behalf of Quarterra. and then turn it over to Mr. Ray Crocker to talk about this a little bit. I wanted to say, I don't know, I understand that you all have not had an appeal hearing before, and why we're talking about these documents, because whatever party loses, and if there's an appeal had to Superior Court, it's limited to the record that's before us. So any testimony, any documents, all that can be read into the record. So that's why we're talking about the record and making sure that it's clear and complete, and the information that we've submitted, and all of the documents that we submitted. I'm sorry you all hadn't seen that. We submitted that originally on October the 3rd with our appeal. All those documents are provided as a part of that. I wanted to say one thing. I wanted to try to level set what we understand we're doing here. We're not here to ask you all to consider a zoning application. That's not what we're here for, whether the use is appropriate or not. I have friends in the audience who live in the neighborhood I didn't know that do or don't support the use. We're not arguing their opinion. We're not arguing anybody's opinion. What we're arguing is that we came to the city, however you feel about the project, you have to be concerned as a City of South Fulton resident that a developer comes to your city, one of the largest developers in the nation comes to the City of South Fulton and says, we want to develop in your city. And we're looking at this land, and we look and see, this is what it says we can do here. Tell us whether we can do this or not. And so that's what happened. And the city gave us a letter and said, you can do this. And then we came back and wrote another letter and said, hey, well, we understand you wrote us a letter, but this is how we interpret what you said we can do. It wasn't smoke and mirrors. We didn't come in the dark, hide in the corner, and give them tricks and bags and play games. We had a conversation. And Mr. Crocker gets up here, he's going to tell you how many times over the course of a year and $900,000 spent that confirmation that in that short letter was affirmed multiple times over that year. And so if anybody feels however they feel about this, you've got to be concerned if you want any kind of development to come to the city. Someone said, hey, well, we want this type of development to come. There's no developers going to come here that if they believe that they can ask the city, can we do this? The city says, yeah, you can do it multiple times over a year. You spend $900,000 and you tell them, I'm spending money. Are you sure I can do this? And then a year later, you say, okay, well, we changed our mind. And they didn't even tell us that. They didn't write a letter. They didn't call us. We didn't figure it out until something was pulled from the agenda. That's how we found out. And we still don't know. We heard tonight, the first time we had an explanation. Is that how you treat the development community? And then you're going to say you want other developers to come? Everybody's concerned about this. Everybody in the development community, the ones you want to come, are concerned. Because it costs money to get to the point where you're going through the permitting process. And so that's what we're fighting about here, process. Not substance, really. We're talking about process at this point. And you're talking to one of the largest development companies in the nation here who's watching this. The other thing I want to say is that this 2024 zoning that the Council for the City referenced was a rezoning. It was a change in use from assisted living to age restricted. When you do a change in use, that is a rezoning application. That's why it was a rezoning. In addition to that, since 2001, the city has done a lot of things to make changes on this plan that there was never any other rezoning, because that's not a rezoning. So it's very clear that this is not a rezoning application. The city said it. I don't know if you tell me the letter was short, does that mean the director didn't review the information related to the 2001 zoning in making the decision? Was it reckless? But there was no smoke and mirrors on our part. The other thing I want to say, this site plan, I want to get back to it because I just hope everybody understands what we're talking about here. Because when I go through a rezoning application, a lot of times when we sit down, we say, we want to build this big, pretty building for you, and we want to rezone the property, and we're going to build this. And the community says, well, how do we know you're going to do it? How can you promise? You say you're going to build this building, but now the building's over here, closer to my house. I didn't want it there. So we give you a site plan, and we lay it out. You've seen these site plans. This is where the buildings are going to go on the street. This is where the parking's going to go. This is where the sidewalks are going to go. This is where people are going to park. And when we build it, we're telling you that we're going to build it to this site plan. That means that's what the council meant when he said site plan specific. Everything has to go where it says on this plan that you approve when you approve this zoning. That's not what this plan says. It says conceptual only. Doesn't mean the parking of the buildings have to be in any particular place. It specifically says the opposite. And there's case law throughout Georgia that makes that clear. So when you hear site plan specific for this zoning, the case is over. The court's not gonna agree with that. And so we're here trying to have a conversation with you all about how do we move forward? How do we move forward? Because this money, you can't just say, sorry, we approve, and, sorry for spending $1 million on this project. There were assurances granted along the way. The law says, if I come to you and ask you for permission, you give me that permission, we rely on that permission, and we spend money in reliance on that permission. You can tell us go away, but you got to pay for it. So we need to have a thoughtful conversation and change the conversation from what we want to see on the property to what happened here. We should all be on the same side. They didn't come to the city of South Fulton to be in an adversarial posture with the city. We went to the council member, we went to the staff. Everybody on the staff knows Ray and Taylor. They were here all the time until the plat was pulled from the agenda, and then everybody got alligator arms when we wanted to talk to them. No one wants to talk to us. Now we're persona non grata because somebody decided that something didn't happen the way it was supposed to. I could understand it if we were in here tricking somebody, if we went and slipped in when nobody was looking and wrote something on the plan, say, oh, see, we can do that. That says it. That's not what we did. We pulled a 2001 file. We gave the entire file to the city and said, look at it and tell us what you think it means. That's what happened. So we regret that we're in a position where we have to be adversarial to a community when we were really just trying to do what we were allowed to do as of right. And then developers don't go to communities to go negotiate what a site plan is going to look like if it's already entitled. That's just not what happens. That's the first question I get when they come to me. Hey, we want to put this on the property. Can we do it as of right? And then what are the development standards we have to meet? If we have to rezone it, then we go to the community. So we don't want you to be offended if they didn't come to the community when the city told them in July of 24 they didn't have to. That's why they didn't go. They just went and started putting together a development plan and going to the city and spending lots of money in reliance on that. If they were doing some trickery, that was a huge risk to spend $1 million hoping that you all wouldn't figure this out. We believe we disagree. The city attorney agrees with me because he's saying it's site plan specific. I know it's not. We go to court, it's going to be reversed if you all rule in the city's favor because that's a factual inaccuracy. It's not site plan specific. There's language we can cite that's in the book. If you look at the 2001 zoning, it very clearly says conceptual only. That's not even concept. That's conceptual only. There's no specific site plan associated with it. And so I just wanted to make that clear. I make sure you all understand that's our position. And I'm going to turn it over to Ray Crocker to kind of talk a little bit more about what happened in this process.
Please state your name and address for us, sir.
Yeah, Ray Crocker, 55 Chafin Road, Roswell, Georgia. Is this on? Yeah, so I'll expand on the site plan conversation. We knew it was conceptual only. We spent more than 4 meetings talking to the city about this. We went down initially, laid out our plans, talked to them about it. We showed them the letter. We showed them all of the zoning documents. We showed them everything that we wanted to do. We scheduled a pre-conceptual meeting, which is required by the city, which has all the departments. We reviewed our plan specifically, talked about storm layouts, talked about entrances, exits. The specific plan that you're looking at that we're proposing was reviewed, no comments, no objections. There was absolutely no feedback to whether it was objective because we were trying to meet a conceptual plan from 2001. That was never, ever brought up. They had the opportunity at the initial meeting in August 21st of 2024 to tell us that this did not meet a 2001 plan, did not tell us that. We came back, met with them again on a pre-development meeting on September 18th. During that meeting, the plan was refined further. We spent more money relying on the initial conceptual meeting that our plan met all their requirements. We talked to all the departments. We talked about the initial zoning conditions that were in the initial zoning. We talked about those conditions and how we were meeting them. We talked about everything that we were laying out, that our plan was not a townhome. It was a multifamily designed under the IBC. It was not designed under the residential code. It was a single parcel development. It was not an individually platted development, as you would see in a townhome community. We walked through this exhaustively with the city to make sure, as we progressed and spent more money, that we were within the requirements of the zoning. Taylor Harper sent a follow-up meeting of our understanding, a memorandum of understanding of what we understood, that our plan was approved and we could move forward. I'll also point out too, in Mr. McClendon's letter, he says, once you show us a plan and once you demonstrate that you've met the zoning conditions, you can submit for permit. Okay, we did that in our pre-conceptual and our pre-development meeting, and we moved forward and submitted permit. They accepted our permit. They reviewed our permit. They reviewed it multiple rounds. They gave us comments. We responded to those comments. We got all the way to an approval. In their system, they approved our plans, and it wasn't until our plat got pulled from the agenda that they went back and disapproved our plans. And that was done through a conversation from someone on council as a direction, as we understand it. I think there was something said here by one of the people that were opposed. Donald said that.
Sir, do me a favor and pull the mic toward the center or either. Yeah,
That he represents the whole neighborhood. We presented to Sandtown Community and Sandtown Center HOA, both. There was one strong opposition, which was the gentleman that you heard from. There were multiple positive conversations from the community about what we were doing, how it would bring their children and their grandchildren back to the community. I think it was misrepresented that everybody does not want this. I'll leave it at that. Thank you. 3 minutes.
You reserve it. Okay, the city want to rebut? And how much time does the city have?
11 minutes, 27 seconds.
Okay.
If I can refocus our attention to a couple of things, is it possible to refer back to the PowerPoint? First, I do want to address something that was just said. There was a comment made that, unless I misheard it, and if I did, I certainly don't want to misrepresent it. There were comments made about this plan being accepted, and I think the word approved was also used. But I just want to be clear, there has not been an approval of a permit in this case. There has been conversation back and forth. There's been written correspondence back and forth. What happened on September 3rd, 2025, that's being appealed tonight, is that a staff member in the planning department said, planning department changes this from a green light to a red light. That wasn't a denial or an approval of a permit. That's the decision that's being reviewed. If we can go back to the beginning of the presentation really quick. Again, I'll try to be brief. Next slide, please. And I want to focus this board's attention on what the decision is before you this evening. So the decision is, you're being asked two things. You're being asked, one, was there an administrative official's action that was based on an erroneous finding of material fact? In other words, and the person we're talking about here is Ms. Tomini, and we're going to look at what she said in just a second. So first, you're looking at, was she making her statement based on an erroneous, was she taking her action based on an erroneous finding of a material fact? In other words, was she just wrong in what she was saying? Were her facts just wrong? Or was she acting in an arbitrary manner? She was just making it up. So let's look at what she did. So again, those are the two things that you're being asked. You're being asked on September 3rd, 2025, did Ms. Tomini make a mistake of material fact, or did she act in some arbitrary manner? Was she just making it up? Can we look at the next slide, please? Oh, I'm sorry. Let's skip ahead. One more and one more. Okay, so this is Ms. Tomini's statement. So again, this is the thing that's being appealed. She said, she wrote, this development does not match what was approved in the site plan for zoning petition 2001Z0079. Let's stop right there. There's no question of what that site plan was. There's a disagreement about whether They had to comply exactly with that site plan, or at least the concept of the plan. There's no question what the site plan was. So this first statement that Ms. Tomini makes, she says, what you're proposing, Quarterra, your 200 apartments does not match what was approved in 2001. Was she right or was she wrong? That's for you to decide. Was she just making it up, or was she referring to the zoning documents that have been in the public record since 2001 and that this very large corporation, Quarterra, was fully aware of? So that's the first thing. If we look at the next sentence, the zoning case, in other words, that zoning petition, that 2001 zoning petition, has this area designated as Pod 5. Remember, we looked at the map where it shows what Pod 5 was originally designed to be, which is a town center that contains community services, commercial components, and residential components that contain loft apartments, townhomes, and an assisted living facility. So the question to you is Ms. Tomini making that up? Is she acting in an arbitrary manner? If she's not, then respectfully, this zoning board of appeals should affirm what she has said. Again, this isn't a rezoning application. It's just a question, was Ms. Tomini acting in an arbitrary way, or was she just completely wrong about the facts? Well, what facts does she cite? She said, when I looked at the 2001 zoning, I saw these things, and it's there. And then, we looked at what those things were, and it's not what's on your plan. That's the decision that they're appealing. Was Ms. Tomini wrong? Did she make a mistake of material fact, or was she just making it up? I submit to you that she was not. Other than that, I'll just say that the city has at all times endeavored to do the right thing in this case. There is back and forth. Zoning is a process, and I'll tell you, especially when, and I'm working on other cases. I'll just say I'm working on other cases where we have to go way back into the past and review these zoning documents, and we discover things as we go along. That's part of the process. This is a 2001 zoning. Part of the property was rezoned in 2004. There was a lot to go back. The file is in the record. And as the city went back and went through this, they said, wait a minute, I know we've had a lot of discussions, but what you're saying doesn't match this, and so we need to push pause right here. They still own the property. If they want to build something different, they can apply for that. But the decision before this zoning board of appeals tonight is: was Ms. Tomini acting in an arbitrary manner? Was she making some mistake? And the decision that she made, it's right there before you. So that's the question for you tonight. Thank you.
Okay, you want to slip on? Okay.
Mr. Chair, board members, thank you for this time. We're going to be very brief. I'm going to make a couple comments, and I'm going to let my colleague close. I wanted to make clear.
I'm sorry, can you let him know how much time he has? Oh,
I'm sorry?
I wanted you to know how much time you had.
Oh, I'm sorry. Thank you. All right, I'm going to talk very fast here. I just wanted to give you my own interpretation of the standard of review that you all are, and why we believe this decision is appropriate to overturn in this instance. The standard here is erroneous finding of material fact, or it was made in an arbitrary way. We believe both prongs are met. The erroneous finding here is that it rests on an erroneous premise about a conceptual plan that was never a binding codified limit on the 2001 zoning. All the facts in the record and all the actions that have taken place, even the record, the actions that counsel for the city referenced, supports our conclusion. And we are confident, we would hope that you would rule in our favor, but we're confident that this court would support that conclusion too. And we say that with all honesty. The second point is the approval of it was carried out in an arbitrary way. Because when the decision was made, we weren't told anything. It was pulled from an agenda, and we had to go begging somebody to talk to us. Karen Tomini and Matthew Williams, we had to corner them in a room, and they took us in a room and told us, well, this is what's happening. To this day, we don't have anything in writing from the staff. If you don't support what we're doing, you should support a process that is clear and open so that anybody from the development community is entitled to know what the process is. You can't walk around and believe that this is the way that you're supposed to do business with the development community. And we're very concerned about that. I want to let my colleague close very briefly here. I've talked too long.
Good evening again, Chair and members of the board. I believe all the pertinent topics have been covered, and I have just over 60 seconds. I want to reiterate that I do believe that the erroneous standard has been met because the site plan, as it's been referred to, was conceptual only. And so even taking the city's council at their word that Ms. Tomini found that it was inconsistent with a conceptual only plan, even taking that as true, it's an erroneous finding, because as a conceptual only plan, it was not site plan specific and it was not binding. The other point is I won't touch on the arbitrary component that my co-counsel has already touched on because I don't have time, and I believe that point was well made. The other point, and just to clarify the record, there was a comment made by the city's council that there never was an approval, despite our client having come up here and stated that there was. I want to point the board simply to tab E, Exhibit E in the binder. This is the first Exhibit E, so a few tabs from the front. And you'll see there's only one page under this exhibit, or the first page. And it says on August 18th of 2025 that the planning review was approved, and then it was later reopened and disapproved, which is the matter that we are in fact appealing this evening. Thank you for your time and attention. We certainly appreciate it, and we hope to be partners with the city of South Fulton moving in the future. We appreciate your time and consideration and respectfully ask that this appeal be granted. Thank you so much. It's the first E, and Mr. O'Donnell, you've found it. So where he is, if you want to, and Mr. Rome as well. Yes. Sure. Thank you.
Anyone from the city? Yeah, you have time. What's the city's time?
He has 5 minutes and 28 seconds.
Well, I think it's just based on time. He's got 15 minutes. He's got time remaining. Hang on one second. He's got the 15 minutes that we already voted for him to have. Take your time. Calm down. You've got the floor, sir.
Okay. My understanding is that there is a little bit of time remaining from the extra 15 minutes that was allotted to the city side. And really the only thing I have to say is that as far as the approval, I'm not trying to quibble with what's in tab E. I'm talking about there was no permit approval, like a land disturbance permit. That's what I was trying to say. In other words, there was not something in hand that would have allowed the development itself to go forward. That's the distinction I wanted to make. I do believe that there were some more comments that citizens wanted to make.
State your name again for us, sir, when you come back up.
Again, Donald Barnes, HOA President, Sandtown Center Subdivision, 5373 Stone Cove Drive Southwest. I just want to go back about 20 minutes into a conversation where he made reference to him coming and talking to, or not coming and talking, but having a conversation with the homeowners of Sandtown Center. We did in fact have a meeting. We did in fact look at some renderings of what they wanted to do, and we did in fact make comments of some modifications and some designs of his renderings that we liked. However, we never gave the opinion that we wanted rental homes built next to our community. Never did we do that. So I want to make sure that you understand that although I'm the only one here, or there's only two of us here that spoke about this, wholeheartedly as a community, 323 homes, we are against
this development. Thank you.
All right, looks like city has 3 minutes, 40 seconds of time remaining. You wish to use it or give it back?
I don't think we have anything further at this point. I think we do have something further at this point.
Carlos Alexander, Assistant City Attorney, City of South Fulton. I believe that part of the crux of the appellant's argument is that they're being treated unfairly because they were not given notice. But if you look at the original letter from 2024, it states that they must meet all the zoning requirements. And Attorney Hilliard mentioned that Quarterra is one of the largest development companies in the nation. They're experts. They're experts at reading a zoning document and understanding what's required. What's required in that document from 2001, they knew. They had access to it, and they knew what the requirements were. They did not meet those requirements. They presented a site plan that did not meet those requirements. Therefore, that's why they have not been approved to move forward. But they are not being treated unfairly because in the 2024 letter from our director, they were told that they must meet all the zoning requirements.
All right, 2:35 left, and I believe the applicant side is out of time, correct? All right, so at this time, I'll take a motion from the board to close the floor for public comment.
I make a motion that we close public comment.
I second.
It's been properly moved and seconded to come out of public comment. All in favor say aye.
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 Any opposed, nay? Hearing none, public comment is closed. We are out of public comment at this time. We're going to open the floor for the board to present any questions that they have of either side. As it is our tradition, we're going to start with the district where this development is taking place. So, Dr. Blackshear, do you have any questions? And after Dr. Blackshear, I'm going to go to this end because I usually start on this end, but Mr. Johnson, you'll have the last word. Dr. Blackshear?
Yes, I do have questions. Good evening, gentlemen, both sides. Can I see?
Who's your question to? We want to get them to step to the podium,
Oh,
or is it just to the group? and
no, it's
whoever
to
want-
these gentlemen here, to the Katerra group.
Okay, one of you guys want to step to the podium because you need to respond into the microphone, whichever you want, either the attorney or the developer. I'm sorry, Dr. Blackshear, go ahead.
Thank you. The site plans, can you pull that back up again? The ones that you're looking to build, the apartments that you're looking to build?
Who's over there? Did they have them up there? That's over there. There it is.
Okay, that right there. And with all due respect, no disrespect intended, I grew up out here. I knew what was there before. It was projects, Boat Rock projects to be exact. That's what I don't want to see again. I don't even want it to, because right now, as soon as I saw that, that's what it reminded me of. Which, you know, I had a lot of friends who got killed out there and who moved on and built new lives outside of that. But that's what it immediately took me to. With this being rental property, how could this bring value to those homeowners in that area? How could that bring, not just putting money in the Katerra Group's pocket, but how can that really bring value?
So we were about a 30% discount to ownership. So if you want to write a check every month and you just can't quite buy right now, you could live in a nice community like Sandtown. You're saying that the layout reminds you of the project. So let me remind you of one thing.
It took me back.
Right, I'll remind you of one thing, the site is zoned for multifamily. So someone could come in here and build 3, 4-story, whatever the code allows them to build.
Right.
We studied the market, we really understood what this area should feel like. We understand there's single-family residential homes in the neighborhood. We see that there's 3-story traditional garden, large, tall, 3 and 4-story buildings next door.
Right.
We wanted to fit in the community more with a low-intensity product, which was a 2-story townhome, and that's what we designed. Looking at it from this plan, it's not very appealing.
Right.
But if you look at our elevations and look at what we're bringing, these are, check right every month is $2,600 a month for a 2-bedroom or 3-bedroom. These are 2s and 3 bedrooms with dens. You know, you're going to bring, it's not going to be a low-income projects, I guess, if you would say that, community. It can't be. It's professionally managed. We have full on-site staff. We have full maintenance. We have gates, fully maintained by, I mean, just like any other multifamily residential. It's just the product type is a lot less intense. It fits the neighborhood much better.
And
Yeah,
what
these
was
are-
the
these are market rates.
percentage of people who live in that area? Did you all did you all do some type of study to determine what's the percentage of people in that area that were open to this?
We did not take that. We opened the conversation for questions and
Right.
answers during our 2 presentations to the communities.
Okay.
We met with the local group twice, a year previously, when Lennar Homes was gonna build single-family residence on the remaining land and over by the lake on the remaining land.
Right.
We presented to the local community then, and then again when we went back to present this plan.
Okay.
But we heard positive things, and we heard a few negative things. So it was, I would say 50-50 from the comments that I got during the presentation.
Right. But you wouldn't be certain if
No.
they were legacy people such as myself.
Right, I wouldn't know the
Right.
opinion of people that didn't speak up.
Right, no. I understand if there was no tally taken with their logistical information.
There was not.
What is the reason why, or is there a reason why we can't build homes for sale versus can these 2-story townhomes be sold versus being rentals?
They could be sold if the property's rezoned to allow more single-family for sale, fee simple, for sale property. Currently, it's zoned for 200 multifamily.
Okay. I have some more questions, but I will defer at this time, and I'll leave the floor open.
Can I give you just a little bit of a further response to this? And-
Sure.
And with all due respect,
Sure.
Dr. Blackshear, I just want to make clear, and your questions are good and valid, they're important, and we're taking them seriously. I want to make sure you understand this appeal hearing, those questions are not relevant. And I'm not saying that because we don't want to hear them and we want to talk about them. And I'll tell you, when we file this appeal, counsel for the city will tell you that we also asked for an opportunity to talk to the city because we didn't want to come here in this posture. We didn't want to be adversarial.
Right.
But this appeal is only about not about what you can do, what's appropriate.
Understood.
And to the extent that the board makes a decision based on those issues and not the standards about erroneous and arbitrary, it's against the city's interest to move in, to make a decision based on those issues. But we're willing to talk to you about that, and we want to talk to you about that and have a thoughtful conversation about it, because Mr. Crocker answered that question exactly right. The proposal to develop this property was based on what the property was zoned for. And the other issue is that I understand that there's a disconnect because I do a lot of work in the city of South Fulton. People don't feel like a multifamily for rent is appropriate, although the market says this is the area where it should be. And it also says that if you bring more rooftops, that some of the other services and quality of services you want are going to come as well. So there's some disconnect in the community and with the development community about what that means, and it's with respect to you. But we want to make sure you understand, even if you're against our appeal, the best thing you can say on the record is something that responds to whether this city acted arbitrarily and erroneously in just saying that there's a site plan as a part of this proposal when it's not.
I understand
Yeah,
fully
yeah.
what the reason is, but I wanted to still inquire.
Absolutely.
Because it was brought up.
No,
And it was
absolutely.
presented, so I still wanted to just make my feelings known, about, and don't get me wrong, I grew up in a subdivision, but I had a lot of friends who grew up in Boat Rock projects. So that plan just took me right back there.
No, I understand.
And since it was presented, I just wanted to address some things and understand what's gonna be the value still to the current homeowners,
The
other
retention.
than, Katerra making money.
Sure. What we put on all of our communities is a CARES program. It's where we give an apartment to usually a husband and wife. They are the liaison between our management company and new tenants. They set up events for the community. They create a place that people call home. And in the community of all townhome style apartments, your retention rate is 50% more than you have in a traditional garden style apartment. So you're gonna have friends that live there, they have the same interests, the children's are friends, and they stay longer. You have a natural security with the longer tenancy in a community like this versus what could be built here, which is your traditional multifamily. Our CARES program is on all of our properties. Someone will be there 24/7. Like I said, again, it's staff, full leasing office staff, maintenance staff on site. Not sure if that answered all
Well,
of
I
your
was
questions.
looking for more so of I wanted to know if there was a monetary value. Will there be, an increase in the value of the homeowners that would be?
Sure. I think, I don't know what these will appraise for per unit. I believe that's in our underwriting. Wasn't prepared to discuss any financials of this, but I could ask Taylor if he knows what they're about 360,000 per door is my guess at this point. Per door. So how that compares to a townhome in the community. These are 1,450 square feet, 1,450 square feet compared to the others at that value. I don't know. We haven't done an appraisal in comparison.
So all of these will be townhomes, not apartments.
They are apartments. They're designed as apartments.
Gotcha.
And they lay out and they live as though you have a neighbor next door to you. It's horizontally attached multifamily.
Okay. All right. Thank you. I'm done for now. I will have some questions later though, possibly.
Ms. Evans?
Yes. I'd like to still speak to you. Could you clarify the 30% that you mentioned? Is that a tax credit for that property or just?
These are market rate.
Just
It's
market
not tax
rate.
credit. So
Okay.
the same cost, we run the number of, if you were to purchase this unit and you have an HOA, your taxes, insurance, and your maintenance on that, we're roughly 30%. The monthly check rate is roughly 30% less than
Because I was thinking you were mentioning tax credit. Okay.
No.
Okay.
that. We are not.
And I think the only other question, I saw something about active senior. Would there be active senior or this, so that wasn't,
We would,
was I
we
reading?
would welcome active senior here, but it's not zoned
It's not, it's
to
just
be
gonna be
specific.
multifamily.
Correct. It's market.
And you are, even though you're Cortera,
Yes.
you're a subsidiary of Lennar?
Lennar, yes.
Okay.
We are.
All right, and just to clarify, I know you keep mentioning, you mentioned to the other board member that, so basically I'm feeling that even if we vote, no matter what we vote, you're moving forward with this and you plan to move forward, if it's not approved by us?
I can't speak to
evening?
what Cortera has done here, but
Yes.
we have formed the legal conclusion that the decision that was made here was arbitrary and capricious, and we're asking this board to agree with us. Again, we didn't want to be here. We can show you the emails, how many times we've asked to meet to try to resolve these issues and have some of the conversations that you all are generating, but the city was not interested to do that. I can share those emails. And so right now, they can't just walk away from $1 million investment over the course of a year. And so if you all decide to rule against us, we believe that there's legitimate grounds already based on how the city decided this to challenge this and go forward with the project. That doesn't mean they're not willing to have conversations with you about the project and the design and all these issues that Dr. Blackshear, because I'm down here all the time, I don't want anybody looking at me sideways or tripping me on the street and all that. I've got a 15-year-old I got to be around for a little longer. And so we're committed to this, but we're just asking you all to understand and hopefully agree that even whatever you feel about this project, everybody's making very good points. We've got friends in this room, I didn't know we were going to be here. But whatever you feel, I believe your duty is to make sure that the process is fair, understandable, and when a developer comes to this community, they know what the rules are. And if they follow those rules as the city director says you follow them, that there's nothing else we can do. We're asking you to make a decision that reflects that reality, not what should be on this site. He's going to do what he needs to do to make sure that there's input from the community, but don't tell them you spent $1 million, sorry, because we just don't like your project, because that's not the question before you. The question before you is what is fair, because otherwise you're going to start getting developers in here that aren't at the level of this company, because they're not going to want to come, because they're going to say Cortera spent $1 million based on a bunch of yeses until they were told no, and then they said, well, please help us, and they said, no, go away. And if you want your $1 million, go figure that out somewhere else. That's really where we are right now. So we don't have an option but to challenge this if you all rule in a different way. I mean, maybe because we believe the law and the rules and their standards support it.
But my question about the conceptual only, that you keep mentioning, but if that's conceptual only, so are these plans, so if you're saying that he didn't have to abide by that, so what makes it, like all of this in this binder, is this only conceptual? Will this change?
No,
So-
let me explain. So in 2001, there was a conceptual plan put together by the developer. That plan had probably no real engineering done. They didn't know if the roads could go there. They didn't have buyers for the different parcels. They put a conceptual plan together in 2001 with Fulton County that said this was what can be built here. And here's how it would lay out conceptually. So that's the plan that we're talking about is conceptual. We had a pre-conceptual meeting with the plan here with the city. Our conceptual plan was reviewed. There was no comment about that not meeting some 2001 plan, which was conceptual. But we responded to the city with a letter confirming that we're moving forward because of the back and forth with the city, talking about entrances, exits, stormwater, fire, all of the people. So we took that plan and we got approval from my investment committee to spend more money to go refine the plans further. And then we had another meeting. Then we eventually submitted plans for permit and they were eventually approved in their system. No, we didn't have a permit in hand. They were approved in their system and then ultimately denied.
So would this be your finalized plan? So would
Yes.
this be what we would expect
That is
upon
it.
if it was approved
Our
and you move
plans
forward?
are ready to pull permit, and we have to submit building permit, but it would fit the plans, fit the site plan.
Okay.
So that is
Thank
not
you.
changing.
Ms. Jerome?
Hello. So I have a lot of questions, but I do want to stick to the reason that you're here. And so our attention was brought to Exhibit E, and the history in Exhibit E in this binder reflects that there were planning reviews added on March 2nd. Planning review disapproved on March 17th, approximately 2 weeks later. Planning review, re-review required, and that was in August, okay? August 6th, and then there was another approval there on August 18th. Then, on August 28th, the planning review was reopened and then disapproved on September 2nd. So is this specifically why we're here? You're talking about this time frame, and this is where you spent the $900,000
We spent
during this
the
time frame?
No, we spent the 900,000 from the point that we've got the letter from Reginald that says that we're zoned to the point that we submitted plans. July of 24 to the point we are here
Okay,
today.
okay. The dispute, is it about what's on this page, about the meetings that you had where you were told that approvals were made by the city and then pulled back? Is this what we're talking about?
The dispute is, yes, them denying our plan and then us asking, us asking multiple times why were we denied. It was ultimately denied, a plat was denied, which led us to ask the question. If you guys open our affidavit, Taylor Harper and my affidavit, it walks you through the timeline and gives you exhibits that are in there that reference the exhibits that will walk you through the exact timeline of what happened and how we got to this point. But what we're disputing is that our plat was pulled. Council member that pulled it told staff to disapprove us and make us go through rezoning. That's what we're appealing.
Okay, and you'd
After
like
we
to.
were approved.
Okay, so you had a discussion about rezoning and want to move forward without having to rezone, basically.
Correct. We have spent the money to refine this plan down to the detail with city comments. The plans are complete. Having to change the plan will probably cost another $500,000.
Well, in this dispute, the crux of this dispute is not whether the city gets to deny approval. You know, if they make an error in the judgment a year ago, the law says they can undo that error, and the city has no problem. You can't create a right if you make an error. The city's not saying they erred in any way. The city is saying that the conceptual plan is a condition of this zoning, and we're saying it obviously is not. But that's not what the city attorney said. The city attorney said this was a site plan specific. That's different than a conceptual plan. Site plan specific, if it was site plan specific, we wouldn't be here. We'd agree. We know that that's true. But this is a conceptual only plan. And so what we're arguing is only that it was an erroneous conclusion on the city's part, a year and a half later, $1 million in, to say, hey, we know we looked at this for you 1,000,000 times. We know you came down here over and over again. We know every time you met with us, you wrote us an email or a letter confirming what we said to you. But guess what? We just realized that this conceptual language on this 2001 zoning that we looked at in July 24, and we keep looking at it every time you come in here, it means you got to meet that. And the law, and it's clearly not true under the law. Conceptual plan is not a condition of this zoning. And that's what we're arguing about, and that's what we're asking you all to consider.
So to be clear, the only plan that you all ever came in with is Emblem Sandtown. That's it. There were never any other plans that you all came in with and changed later.
No.
Okay.
Just to be clear, this site, the buildings moved here and there as we engineered it and got the roads correct. I mean, just make sure I'm answering that correctly. Yes, the plan shifted and massaged as we went through final design, but that is the plan. We came in with 200 multifamily homes on that site.
And they were always rental units?
They were always rental units, and those were presented to the neighborhood as rental units.
Okay. This is just for my information. The money that's been spent, the $900,000,
973 to be exact.
973. Those are all considered pre-development costs
Those are pursuit costs and legal expenses that we've spent today.
and legal. Okay, that's all I have for now. Thank you.
Is that it, Mr. Jerome?
That's all I have for the moment. Thank you.
Ms. Faraday?
Okay. I got a couple of questions. It is, well, let me just start here. Okay, so it sounds like to me that, you know, we do have rules and laws that are set in place to be followed. And from my understanding, developers feel like we did not, well, the city did not follow those rules that was set in place. My first question is, do you have I know you guys said that it was approved. Do you have that letter of approval? I know you gave us a binder, a whole bunch of information, but do you guys have that letter of approval?
There was never a letter sent, so if you follow the affidavits and follow the timelines that are specifically, it references this, and it shows that the plat was pulled. A couple of days later, there was a note from someone on staff that says, hey, pull this out of approval, and then 2 days later, it was denied. So there was never a letter issued to us. The plat, we had to get our plat approved prior to our final plan civil permit being issued. We went through several rounds. I think we were on our third round of comments back and forth with the city departments and our civil engineer. During that same time, a plat was sent to the city for their review and approval. They approved, recommended it on the consent agenda to city council to be approved. It was put on the city council agenda, and the district councilwoman pulled it, was it in July or August? I believe July, asked us to go talk to the neighborhoods to make sure everybody understood what was happening. She understood that it was zoned, and then we put back on the agenda. Then it was pulled the second time with no explanation, again, after we did exactly what she asked us to do. Yeah. And then from there, after we did what she asked us to do, it was pulled again. Then we requested to get explanation from Mr. McClendon. We had to show up down here. We ended up talking to Matthew Williams and Karen Tomini. They said, if you want to move forward, you have to get it rezoned. And we were like, what are you talking about? He said, speak to the councilwoman. That's who made the decision.
I got a question for the city. Is there any particular reason why the city did not communicate to the developers the decision to to deny? Because they're saying that they kept going back and forth with the city, and the city did not communicate with them until they had to keep coming back and forth, and now we're here. So is there any reason why the city have not communicated with the developers and give them any type of due process when it comes to making these decisions?
Well, from my perspective, I'm not so sure how much of an approval there actually was to then rescind. Again, there is this process, there's back and forth, and at one point in time in the review process, the planning department had given this green light, but then had changed that. And so I wasn't a party to the communications themselves, so I don't know if there's someone else from the city who could speak to that. But as far as due process is concerned, again, there wasn't, for instance, a public decision that was made that was then reversed or something like that.
Okay. So I'm pretty sure the developers wouldn't have spent that type of money if something was not approved. So that's why I was asking, was it a letter of approval? But you said it was something in writing that says something was approved.
As far as us moving through the process,
Start over and talking to the mic as best you can, please.
as far as us moving through the process is set up to where we get the letter for zoning confirmation. We're confirmed that we are zoned for 200 multifamily homes. We don't have a plan at that point. We put a plan together. It says in the northwest quadrant of the site, that's exactly where we're placed on the site. We develop a plan. We schedule a meeting with the city departments. We come down and show them the plan. We talk through it. We show them the original zoning. We walk through all the zoning conditions. We explain to them, this is what we want to do. Is this okay to go forward? We follow up with a letter. It's in the package. And they accept our plans into permit review. They accepted our plans. They reviewed it multiple times. They had multiple opportunities to tell us to stop spending money, and no one did. No one did. And we felt that Reginald McClendon's letter was correct. His determination was that we met zoning, and we do. We're 200 multifamily units. We met the zoning conditions. The only thing that they're pointing to that we didn't follow was a conceptual plan that was changed multiple times over the years. So to hold us to that without saying it, we're supposed to just assume it? How are we supposed to do that? So we follow the process. We get our plans finally completed. We submit the plans. They accept the plans. They review them multiple times. They ultimately approve it. You see it on there. 2 days later, it's disapproved at the direction of a city council member.
Okay. What's the opposition, what is your name? I'm sorry.
Hakeem Hilliard.
Hakeem.
Yeah.
Because you made the point, how do we move forward? What? The city is saying that, hey, we just want you to go through the steps of submitting a rezoning application, submit a site plan, 1, 2, 3, and 4. What's the opposition of not following those steps?
So I've been rezoning properties around the state for 30 years. And the first question I get when clients come to me, developers say, hey, can I do this as a right, or do I have to go through some process? Because that affects how much money they're going to spend. Then they want to know the risk, the likelihood of success, those questions. So when you find a property that's entitled as a right, it's a good property. I happen to represent the property owner here as well. And I'm aware of the conversations when we made it clear that there was this number of units available. But they didn't want to accept the representations of the property owner. They said, listen, before we agree to go into contract with you, we want to go independently to the city to make that confirmation. So they do their due diligence, and they spent the money to do that so that before they spend the money that Mr. Crocker is talking about. So we went through this whole process. And so the question about what's appropriate for the site was based on what was required. And so we looked very closely at the zoning, formed our own conclusions about what could be developed there, and came up with a plan based on that. And what Mr. Crocker is saying, it wasn't just the letter that the city attorney said. There's a little short letter, and that's how they relied on. It was a little short letter that was followed by months and months of conversations back and forth. And the permitting process is a back and forth. You're submitting plans, they want revisions, but the issue each time is not whether the zoning is allowed. It implies, if they let you go down the process, that original decision about zoning is their position until they change it. I think the issue here is that there was some concern from the community that this project was going through the project process as a right project without a rezoning. And I think that's probably why it was held, and that's why we were told to go back to the community, even though we weren't required to. We went as a courtesy to the council member and the community, and we had a couple of meetings that were directed who we had to meet with. And we made clear this is as a right zoning, but we want to talk to the community. And I think what Mr. Crocker is saying is correct. I think maybe people felt like there was going to be widespread opposition. There was not. And I understand what the gentleman said here, but we got a lot of different feedback from people that felt good about it. In fact, more people that communicated with us were supportive of it. So, but we were out of that process. We were just doing this as a courtesy to the council member.
I see that you guys went in good faith to the community, and as the community stated, that it was some plans that was placed before them that they thought was good, and then it was some plans that was placed before them that they did think was not so great.
Right. What we presented were the building elevations, and we explained that the artistic layout of the exterior siding was done by an architect that we trust, and the look of the building was something that we put the trust into an architect to do, and we liked it on our level. there was a comment that they would like to see brick on the fronts of the buildings, and we said we would go back and look at that, and that was it. It was not a layout of this site plan. There were no comments about changing this to putting it on a different part of the site. There was nothing about that. It was specifically about, I believe one comment was, we want to see more character. And I asked what the definition of character was, and it was just, it's very arbitrary. We believe these have great character. These are not complete. There's a rendering here. So I guess my point is the neighborhood made comments about the exterior siding. It was brick that we said we would look at on the fronts of the buildings.
Okay. And I think that the community, what they're saying is that basically when you own a home, you do want the value of your home to be sellable as well, right? And so what they're saying is that if you put up these apartments or single-family townhomes, or multifamily townhomes, that it may become an eyesore, that people may not want to purchase their home that they're selling as well. So I understand what the community is saying. Hey, maybe not so much that
I agree with that, and I would say this, when they purchased their home, this site was zoned multifamily, so they knew that it was multifamily at that time. There could be something really ugly coming here that I guess the city approves. I mean, I guess my point is that multifamily is zoned here. It's been zoned here since 2001. There's nothing that I'm asking to change about that. I'm just asking to be treated fairly by the way the city led me down the road to spend $973,000.
I understand. I understand. So again, like I stated when I first took the question section, I said rules and laws are set in place for a reason, and it should have been communicated to as far as it should have been communicated of why. But again, I don't know if the city did communicate it or not. So that's the question. Was everything done to communicate with these guys so that they wouldn't have spent the $973,000?
Well, of course, how much they've spent, I'm not privy to any of those numbers. That's the first I'm hearing of that amount. I mean, before tonight, I was aware that they were going to say that it was a big number, and I was aware of other big numbers, and the number's gotten bigger, and that's understandable. That's part of the process. What I would say is going back to Director McClendon's letter on July 3rd, 2024, it was very clear that all other conditions of zoning would have to be met. And so, yes, there was a lot of subsequent conversation, and there's a lot of discussion. Frankly, there was a lot of discussion about, the definition of an apartment versus a townhome based on what these looked like and different things like that. But as far as we got further down the road, leading up to just a couple of months ago, back in September 2025, I don't have any additional information than from what's in the record about the communications about the staff member entering into the portal that the application could not move forward as is. But again, I would say that it was very clear in the letter from the beginning that all other conditions would have to be met, and then in September 2025, the staff member in her review said there were other conditions that this does not comply with.
Okay. The city asked, did this person speak arbitrarily or erroneous? To make sure I'm getting my words right. Or erroneous. The developers, and I know you keep saying it was conceptual, conceptual. Conceptual. Um, do you, do you feel that this person made it up, or was it factual? Miss Taylor Hopper.
Made what up? What do you mean? I'm sorry.
You, what did she asked, about the site plans, did it have all of these, what she, saw at first, it was supposed to have a community, a senior community, it's supposed to have all these great bells and whistles, and then, when she got your conceptual plan, it didn't have any of that. So I think people are confused about the actual and the conceptual.
Yeah.
Am I right?
I think I
Okay.
understand what you're saying.
Okay.
You're under the impression that that our site plan was not shown to her until the end of the process, and that's why they made a decision that was inconsistent with the full year of review. And I think that plan was under review with them well before, and that's, I think, the point, right?
Yeah, I mean, we would be happy to show you the evolution of this plan. It has not changed. There's been a clubhouse and amenity with pool, full gym, the greens,
When did you start reviewing the site plan with the city? That's what I think
yeah, I think I look at Taylor Harper's timeline, and I don't know where that timeline is in here. This would be probably Exhibit A, let's see, maybe B. But the timeline will tell you the first meeting we had with Reggie, and then after that, maybe it's C1. Yeah, Taylor, can you come over here? Where's your timeline? Yes, the timeline. Yes, it's under his affidavit. It will lay out the timeline. Go ahead, Taylor.
So the site plan was first, the earliest iteration of this, oh, yeah, Taylor Harper, with Cortera, 3910 Orchard Road, Smyrna, Georgia. So the site plan was initially submitted for conceptual review in the earliest meetings with the team on the pre-conceptual meetings and the pre-development meetings, both.
Okay.
Which was, yeah, August 26th of 2024 was when it was first, it was part of our package that had to go in for pre-conceptual meeting. And I actually sent a follow-up letter to that meeting on August 26th, kind of chronicling everything that we discussed during that meeting. And within that document does state that we, at that point, wanted to confirm that we were meeting all zoning conditions tied to the property. And that is Exhibit, I believe, Exhibit C. Section 2. Sure. And I may have misunderstood your question, but in the off chance that I did interpret it correctly, I just want to point to the language that the city's council highlighted for you all. Do you mind, if you're controlling the slide, could you go to an earlier slide in the city's presentation? Right here, and I believe this is the language you're referring to.
Mm-hmm.
So the reason why this decision is erroneous is because the supposed zoning requirements referenced in this language, community services, commercial components, etc., were part of the conceptual only plan that actually isn't a zoning requirement. So it's an erroneous decision or language because what she's saying is part of zoning actually is not part of zoning. And that's why it's erroneous, because it was conceptual only. Am I capturing that correctly? Hopefully that answers your question.
That did.
Okay.
That did. Okay.
I would like to just add something to that. It does allow for loft-style apartments, and this is what we decided to do, build 2-story style apartments versus your 3-story apartments. So that is a use allowed in this pod.
Okay. Okay.
Hey, talking to the mic, please.
But it does not, what he's saying is that was a conceptual plan, which is not part of the zoning, correct?
Correct. And just for further clarification, he's referencing the loft apartments. So it's erroneous because she's referring to this conceptual-only plan as if it is a zoning requirement when it is not. However, she also has a factual inaccuracy because we actually are providing loft apartments, whereas this comment says that we are not. So it's erroneous based on the law, and it's factually incorrect. And I think that's what we wanted to just clarify there.
Go ahead, because you know I was about to ask a question.
I appreciate that. I think her comment is being cherry picked here. The question for the Zoning Board of Appeals is, was she materially wrong, or was she just totally arbitrary? And again, I mean, her statement speaks for itself. The fact that there are some things that Quarterra wants to do that would be consistent, the fact that there are apartments that's consistent, that doesn't make Ms. Tominy's statement here arbitrary. It doesn't make it capricious. It doesn't make it materially wrong. She reviewed the 2001 site plan. She said it doesn't match this. And again, back from the July 3rd, 2024 letter from Director McClendon, that letter said that, yes, even though when you look at this entire site plan, 200 more apartments can be built, you will still have to meet all of the zoning
Say
conditions.
the zoning requirements. I got it.
Wait till a question is posed. You have more questions, Ms. Faraday?
I don't. Now,
You want,
you want to follow up with his question?
if I may, I believe it could be helpful.
Step into the mic.
So one other point of this is this 2001 conceptual plan was not a mystery to the city. It's not something that was unearthed and discovered later. I want you to note the date on this comment. It's September 3rd, 2025, when initially the initial approval that was given through the letter, where the 2001 conceptual plan was known about and asked about, that decision came in July of 2024. So this supposed zoning condition, that again is not an actual zoning condition, is raised more than a year after the initial approval was given in 2024. And this appears to be a decision in search of a reason, and this reason that's given respectfully is an erroneous one.
I have no further questions.
Okay, I think Ms. Jerome wanted to follow up, so go ahead, Ms. Jerome.
Thank you. Question for you, please. So, if the current zoning is multifamily, and the issue is that the petitioner needs to rezone, what exactly is the city asking them to do right now? To rezone what?
Well, the city's position is that if the developer wants to build something other than what's shown on the site plan, the 2001 site plan, then they need to ask for a rezoning. The decision letter from 2024 from Director McClendon, what he was asked to do and what he did was he looked at the 2001 zoning. He said, and it's in small print, but it's on that PowerPoint slide, and it's presumably in the materials in front of you as well. But there's a block off to the right-hand side that says how many different kind of uses there are going to be. And for apartments, it says 550. So again, this is 2001. Since 2001, 350 have been built. And so Director McClendon's letter, he went and did the math, and he said, in this site plan, there are 200 more apartments that can be built. Now, the site plan that we've been looking at tonight from Quarterra is just a portion of the undeveloped part, and it certainly doesn't match the 2001 site plan. So the city's position is, if Quarterra came in with a permit to build exactly what's shown on that site plan, no problem. If it's something different from that site plan, then there needs to be a rezoning. And even if we're going under conceptual or not conceptual, conceptual has to mean something.
conceptual has to mean something like the 2001. Conceptual isn't just fill in the blank, correct? It doesn't mean just whatever you want.
So if there's a conceptual plan and there's a deviation from the conceptual plan, legally, the developer needs to submit a rezoning application like you're asking them to do now if you're going to uphold a conceptual plan.
That's correct. Now sometimes this is where discretion comes into play, and the city staff has some degree of discretion to say, is this close enough? Because as has been referenced, sometimes when developments actually start to get built, or right before they get built, you start engineering the roads, figuring out exactly where things are going to be. Like, oh, we need to move this a little bit here, a little bit there, and those types of things often don't cause any problem. Obviously, in this case, it's completely different, and the city staff's decision, I think, is well founded. They said, well, hang on, we need to push pause on this.
So was it incorrect in the letter that's been referenced by Reginald McClendon on July 3rd, 2024, that they are allowed to build an additional 200 multifamily units?
It's unclear. And what I mean, I would say the letter in that respect is a little bit unclear. The way it should have been worded is, there's some of this verbiage is in there, that of the 550, that there were originally 550, subsequently 350 were built, so 200 more theoretically could be built on this site.
Theoretically.
But at that point, there had not been a site plan submitted. Director McClendon was not asked to review that plan and then say, yes, you can get this approved. And the case law site, later on here, talks about how Georgia law distinguishes between conversations such as this and actual permit approvals. And again, the permit approval did not happen in this case. So while there was, obviously, clearly there was a misunderstanding, there was not an actual permit approval that was then taken back.
And I want to address Ms. Jerome's question. Did we make an error? My position is that we did not make an error, that the developer can develop those apartments, that number of apartments within the site plan that from 2001, as long as they meet the other conditions. And the letter says, as long as you meet the other conditions. They knew they had access to this document. This document has been public record since 2001 for 24 years.
What are the other conditions?
You want to speak to that?
The conditions include this conceptual site plan. I have the zoning file with us. This is from the zoning file, but it's there's a list of other conditions that have been submitted.
So the petitioner has not met other conditions aside from the conceptual site plan being changed?
Well, I'll say, I'll tell you what I can tell you and what I can't tell you. What I can tell you is, from a planning perspective, the petitioner, the appellant here, did not meet the conditions of meeting this site plan. Again, even if you just look at it as a conceptual site plan, it's nowhere close to the same. So the staff was, made a well-founded decision to say this isn't right. But there were other city departments as well who made reviews, and some of that I can remember off the top of my head, and some of it I cannot.
All right, go ahead.
And to address your question as to what were the conditions, our position is that the site plan itself is a condition. So he has to meet the site plan from 2001 because that is a condition of the zoning. That is the city's position. The appellant's position is that the 2001 zoning just contains a concept and that it's not binding. So we disagree about that. But that disagreement does not equate to us making an arbitrary decision. Based upon the expertise of the city's zoning department in reading the 2001 law, our position is that the site plan from 2001 is a condition of the zoning and must be met. So anything that we're basing our approvals or disapprovals on is not arbitrary, it's not capricious, it's not something that we're making up, and it's not even a difference in a factual error. It's a difference of opinion about what the 2001 zoning says. but that doesn't make it arbitrary.
So the 2001 zoning is being referenced because this project started in 2001 from a site plan that was created in 2001. 300 units from the original site plan have been completed, or 350. I forget the exact number. And then the additional 200 units are supposed to be an extension of that original site plan. You're allowing them to build 200 multifamily units as part of that same original 550 multi-unit site plan project.
Go ahead.
If I can just say, as far as what was approved and what's been developed, when we look at this site plan, A, B, C, and D have been built as shown. So again,
A, B, C, and D have been built as shown according to the 2001 site plan?
Matthew Williams, Planning and Zoning Administrator, yes. So at the bottom of the site plan, the single-family product that was built, that's labeled A and B has been developed as is. C has been changed, D and F were changed in the 2004 rezoning.
Can you please,
And-
sorry, go a little slow for me? When you say A and B have been built as is, what
Yes,
does
so the
as is mean?
single-family product at the bottom of the site plan here, A and B, that has been built, that has been developed per the site plan.
Per the 2001 site plan?
Correct.
Okay.
In 2004, they came in and did a modification to D, E, and I believe C as well. And that has been developed per that site plan from 2004. The only thing that was left off was F, and the 2004 rezoning specified that F shall be developed as it was rezoned in 2001. And the 2000, and I just want to mention, the 2001 rezoning references all the commercial amenities that are being left out. So that's why we're saying that the site plan is not conceptual in design. It's actually being developed as per the site plan.
Okay, so based on what you're saying, the letter from July 3rd to build 200 multifamily units, those 200 multifamily units could only go where F is labeled?
That's correct. Because everything else is developed.
Okay, and so that was incorrect. In F, they need to build housing and commercial. It needs to be the additional items that were in the 2001 site plan.
No, it can
You're-
include housing as well.
It can include housing,
Yes,
but
but
it
it has to
can't be
include the other amenities.
exclusively the 200 units that the appellant wants to build.
You said exclusively?
Right, because they want to build 200 rental units, and the city is saying you can build housing, but you also have to build the other commercial amenities and businesses that were in the 2001 site plan.
That is correct, per the site plan F, yes.
Okay.
Ms. Faraday.
Why was D, E, and C modified
Your question to the applicant?
to the developers? Yes.
So I wasn't part of that development, but the ownership of the property that we're buying, it was part of it. My understanding is that the single family in A and B were developed similarly to that. If you go out there and you look at where this road comes in, where F is, there is no roundabout, but there is the plan looks totally different. They said that C has been redeveloped. There's absolutely nothing on C. The road goes down south of the lake, which is totally different. If you could pull it up on Google Maps, I'd love to overlay it and show you guys that it is not the same on C. So why was it changed? My guess was that a developer wanted to purchase E and D as a multifamily use, and they proposed it to Fulton County. It was not the city of South Fulton at the time. And they proposed to build 350 apartments, garden apartments on E and D. And it was on a portion of E, and I think a portion of D is where they built it. Now, the seller sold the property to them. They went through the process and built it. I don't know exactly why. I'm going to say that's what the market brought to that area. He may have a better explanation.
I just think it's an important element. The apartments that were built on where E and a portion of D were built before 2004. They were not part of any of this rezoning. They were built, as the Slate community was built, it was completed in 2003.
My final question to the developers is, I asked earlier, what's the opposition? Why would you not want to submit the rezoning application?
Here's the whole problem with this, is that we spent a lot of time tiptoeing through the process with the city. They had all the opportunity to tell us that what in any other law, he's saying that a conceptual plan is not, you do not have to adhere to a conceptual plan. It is a conceptual plan. They had an opportunity to tell us that multiple times. They're telling us now that we have to meet a conceptual plan after we've spent $975,000. If we go through rezoning, I'll definitely do it, but our plans have been purchased. We've spent all the money. All of our architectural plans are designed based on all the interim approvals that we've had. Call it approval or not, we've had verbal conversations. If you see Exhibit C here is a letter where we wrote the city confirming, hey, this is what we're doing. We understand that we're meeting all of your requirements. They had the opportunity multiple times to say, no, you have to go through a rezoning. They never did that. In the 2001 plan says conceptual. What would give us the idea that they want to make a conceptual plan a site-specific plan? Never. I mean, they had the opportunity to do that. I mean, we discussed the plan with them. So the problem is they allowed us to go down the road, giving us multiple rounds of review, and never brought this up until the very end. That's the problem. And in our opposition of going through a rezoning is because there would likely be changes to our plan after we've spent the money at the direction of the city to move through this process with no opposition until the very end.
I have no further questions.
Mr. O'Donnell.
First question is for the staff. Do we have to make a decision ultimately tonight? Does that have to?
Oh, I'll let staff answer, but I know the answer. So. They have 60 days.
The board has 60 days to review everything that's been presented tonight and make a decision.
Okay, thank you. The second thing is, I've been told that there's a binder from the city. I have not received such binder. And yet we want to add that to the record. So where is that binder, please?
So, on behalf of the city, last month, I submitted all of the documents in electronic format, and I have the hard copies over here. But I'll tell you, the material, the key documents are the documents we've been talking about tonight. But all of the documents have been submitted. And I'm happy to provide additional.
You're asking me to use that as reason to support your arguments, yet I don't have it in front of me. Could I please have those documents, even if they're the same?
They've been submitted.
I have not seen them. Also for the city, my understanding is we are referencing a 2001 rezoning case, and that there was a second rezoning, is that correct, in '04?
Yes, and I have both of those files.
Okay, see, that's not in any of this, so I'd like to see that portion of it at least.
This is the 2001, and there's an electronic format that's been submitted that might be more convenient. But.
Yeah, we need to be able to see.
As I sit in for the chair, I am the vice chair. Would anyone like to make a motion to add all of these documents
I'd
to
like
the
to,
record?
I'd like to make a motion, now that I've got it, to add the documents provided to us by the city as well as the binder provided by the applicant into the record.
Anyone?
I think they already done that already.
We didn't. We didn't.
There was no-
we didn't
there was no
formal- There
motion.
was not a formal motion for
I second it.
Motion has passed. We'll
Oh,
move
yeah,
forward.
vote.
Documents have been applied to the record.
I'm gonna vote for it.
Oh, I'm sorry. My apologies. For a vote, all yeas,
Yay.
Yay.
nays. Motion has passed. We will add these documents to the record.
Do you know where the 2004 documents are in this? The rezoning piece?
I believe it's the entire file that you have.
The whole thing is a 2004 rezoning?
I think so. I know that from what I can see from where I'm standing, I know that that's the cover sheet for the beginning of the 2004 rezoning.
Will we be able to get that electronic copy of that if you don't have a full hard copy of it? Okay.
Mr. O'Donnell, I would like to clarify that the 2004 was a modification, not a rezoning,
Right.
and it did not include the portion that we're talking about tonight, which is portion F.
Okay.
Yeah. Could I have 5 minutes just to review this?
Well,
I mean, this is a lot of documents.
Take your 5 minutes.
And I still have, I can ask my other questions if you want first.
I'm gonna come back to you. You said you need 5 minutes, right?
Well, I'd like to hear the responses to any other questions.
You're
So
not going anywhere, right? So you're here.
I can't read and listen at the same time. I'm sorry.
Oh, yeah, that's a problem, because we got work to do. Ms. Patterson?
All right, so, and I appreciate the patience of this team answering these questions because we did not have access to these documents prior so that we would have been able to have read them and asked these questions. But I wanted to reiterate before the people that are from the community left that because judging by what they stated to the body here this evening, their concerns were about the development itself. And that's not the reason why we are here. The purpose for our discussion that's been presented in front of us is to make a decision of whether this pause was something that was done arbitrarily or was it done based on some fact? Okay, so I just wanted to recenter that in this discussion. I do have a question and I will, I'm not sure who to address it to, so I'll ask that you both speak. But can we characterize this discussion? The challenge and issue is that one side feels that they should have been told that there was a problem and the other side felt that they were not told. Is that the characterization of where the issue is right now?
I'll speak to this. So I think you're right. It is about the amount of time that we spent with them, which is when we go step into a development, we do our due diligence. We go speak to the city. We talk about where we're going to build something. We sit down with all the departments. We say, hey, this is what we want to do. We look at the zoning. We look at the zoning conditions. We look at if there's a conceptual site plan. That's what we did here. We stepped all the way through those. And even there were comments from Karen said that you guys are doing more than any of the other developers do. That was the first meeting we had. And it brought us back when we go and we do as much possible as we can to make sure we're doing what the plan and the process is supposed to be. And then no one with the city ever brings this up, that they're going to hold us to a conceptual plan versus a site-specific plan is what you normally see in the zoning codes. Look around the whole state. site-specific, elevation-specific zonings, it's very clear that's what you got to stick with. When you see a conceptual plan, the opportunity to move and shift that around is usually at the city's discretion. We got the letter, says build these townhomes, apartments in the northwest corner. We stepped through a conceptual plan meeting. If you go to Exhibit C, Taylor followed up that meeting. We were early. We hadn't spent any money at that time. At that time, that would have been the time for them to come and tell us, guys, hold on, stop. You've got to go adhere to this. And it would have taken us back. We would have said, wait a minute, we got to go through a rezoning to get our plan approved. Instead, they let us go all the way through it, all the way to our final civil plans being, they were approved in the system. Our building permit plans were developed, ready to submit, because our civil plans were imminent to be approved, and we could submit our building plans immediately after that. It's about the timing.
Understood.
If I can add to that, making a legal argument on this issue is that I think it's a little more than that. I think that it's not, we're explaining what happened, but that's not what the arbitrary action or erroneous actions were. You know, you can be delayed. I think I said earlier, the Georgia Supreme Court said years ago that I can come in here and ask the planning director here to issue me a permit to put a hotel outside this building. And he can issue me that permit. And if that hotel goes up, someone can come and say, well, that's not authorized here, right? That person that got permission to build that hotel can't say, well, I get to keep it, and if you make me tear it down, that's an erroneous decision. If it's an unlawful decision, the city is entitled to say, we're taking that back. Sorry. They get to say that. That's the law. That's what Georgia Supreme Court says. What's happened here is different. It's not just that it was a delay in talking to us. When they made the decision, they didn't come back. If they had come back and say, hey, we misapplied the law here when we told you that you could build this for the last year. And every time we approved this, we made errors each time, because that's what they did. They say we didn't make that decision. They made the decision multiple times. But what happened here is they're relying on a conceptual plan, that the site plan, I mean, I'm a land use lawyer, and it's a struggle sitting in here with a bunch of planners in here, and we're arguing about enforcing a concept plan. It's zoning 101. It's what we teach paralegals. If it's a conceptual plan, it's not enforceable. If it's a site plan specific, it's enforceable. That's why council said it was site plan specific, but he knew it wasn't site plan specific. If it's a site plan, it's a site plan. It's a real plan. It shows it shows what everything is. There is no plan. And so what they said is, we're going to reverse ourselves based on you not meeting this site plan that is not a condition of the 2001 zoning. It's you know, I didn't want to make this argument because if we go to court, the court's gonna agree with what we said, and we're gonna be able to build what we want. That's what I'm telling you. It's that clear. And for planners to be sitting here and saying, arguing with you, suggesting to you that a conceptual site plan is an enforceable condition of zoning, I mean, that's all we have to say, you know? And we knew this before we came in here. That's why we went to the director, who's never responded. I want to put it on the record that he's present. He's never responded to one email, one conversation about anything. We don't have any idea. Only thing he's communicated is, yes, you approved. He's never retracted that. But he's here in this forum participating. And this client has spent a lot of money. He's been asking the city to talk to him, been talking to the city attorney about it. No one's responded. Let's talk about it. What can we do? All these thoughtful conversations that you all are talking about, did you consider this? Did you consider that? We never had an opportunity after we got rejected. Because I guess the city just said, we're going to take it back, put your money in your pocket, go home, and we're going to go away. We can't afford to. They can't afford to do that. And I'm sorry I went further, but I think the issue is the legal question you're being asked. Is it erroneous for the city to conclude that this concept plan is an enforceable condition of zoning for them to be able to tell us we don't meet the zoning? We're saying that a concept plan, conceptual purposes only, is not an enforceable condition of zoning. And I'm confident that there's case law going from 30 years to the day that will agree with me. And so if you decide to agree with their position on that, they lose. And so they need to come up with another argument, because that one won't work. I'm happy to conclude that if you want to decide it based on that, we're done. It just really is not, I can't understand that we're having this conversation with professionals telling you that this concept plan is an enforceable condition of zoning. I think they knew it when we started, it wasn't enforceable, but we tried to find a reason because we didn't want it, because people weren't happy with it. And we're in this position, and we're adversaries when we really should be having a conversation together, because I don't really think we're in different positions, because they want to talk to the community and have a conversation about how to make this work, and we're not able to because of the disagreement about issues that are not really disagreeable, about legal issues that are not really legal conclusions that are proper.
Thank you for answering that question. Did you want to just say something?
Yes, ma'am. Thank you. The crux of our disagreement is that we are relying on the 2001 site plan. When Director McClendon wrote his 2024 letter, he was relying on the 2001 zoning site plan. He was relying on the numbers because that particular letter was asking questions about the numbers that could be built. He relied on the 2001 zoning. So we've relied upon the 2001 zoning, not as a concept, but as legal requirements of the zoning. So we have consistently relied upon the 2001 zoning as legal requirements, and we are consistently doing that. Our most recent decision, which was made by Ms. Tumney, is relying on the 2001 zoning. It's consistent. Our position has always been that the developer must meet all the conditions of the 2001 zoning, and the letter says that.
I'd like to yield my time back to,
You have any more questions?
I want to wrap up what they just said, but I was going to ask if I could return the questions back to Mr. Donnell since he has read, Commissioner Donnell, since he has read.
Well, I'm going to give everybody a chance to talk.
Okay.
Are you finished?
I'd like to just make this statement. The city of South Fulton and the District 2 that I represent, we want the development. We want to attract our city is growing. It's a new city. It's a proud city. The constituents are homeowners. They've sacrificed for their properties, and they want to have decisions that sit around them that will allow their investments and safety concerns to be like places like Roswell. I think you mentioned you live there. So although that is not the conversation, we want to improve the relationship between the development community and our community of the constituents. I would like to see a better relationship with our city government and the developers, because we don't need to be, we're working together, right? My thought is that if there's a way that we can look at this to create a meeting in the middle, I think that that would be something that this board may consider interesting to hear. As far as a move forward plan, I think there are still questions that stand, so I will allow that to happen. I'm clear on what your position is. I'm very clear on what the city's position is. I think if I were to ask a question, I'd need to understand what would a middle ground look like so that we can resolve this situation. What does that look like?
Is that a question you're posing, or that's hypothetical?
That's a question that I am posing.
So Pod F has 12 acres remaining. If they want commercial can come into Pod F. It can still come into Pod F. So there can be, but what I'm hearing is we have to meet an exact plan which doesn't show parking, doesn't show parking count. It's a concept plan. So how do we come to the middle? There is commercial parcels remaining in Pod F, which could meet what this plan's intent was. Now, I'm not going to speak for the master developer. I'm just letting you know that there is additional land remaining that could be, if the market brings it, it could be another use on the commercial side.
And that process would require a rezone to do that. Is that correct or no?
No, not in our opinion, because
Okay.
I would not think that a commercial developer would have to come in and show a concept plan to the city on that 12 acres. And It could be a mix of uses, it could be condos, it could be everything that remains in that entitlement, which there is a lot of remaining entitlement on this master development, could come into that remaining parcel. Now, I hope I don't get in trouble by the master developer speaking for him, but I think that could be a middle ground, just understanding that all of the land, there's several, I don't know how many, is there 30 acres left? The Pod C around the lake has not been developed. This does not show what's out there today. I would like to show a real plan. Pod C is north of the main spine road that runs out to, I believe, it's not Boat Rock.
Baker's Ferry?
Yes. So this plan is changed totally, but all of the land around the lake can still be developed. The land to the south of our proposed plan can still be developed. So a middle ground to me is that everyone needs to understand that there's remaining land that could, the intended use of commercial in this area could come in. If the market brings it, no one can force it to happen. That's,
Mr. Johnson, did you have anything? You hadn't added anything yet.
Yes, sir, I do. Thanks for recognizing me. First of all, I just wanted to say, this has been a long, lengthy night, and thank you, Mr. Hilliard, Mr. Crocker, Mr. Mitchell, and city staff for the presentation. I also like to say thanks, but these guys are left because I'm sure they got to go to work tomorrow morning. Miss Lolita and Mr. Donna Barnes for coming in and staying that long to show they're passionate about the neighborhood. I can respect what you guys are doing for the builder goes, but and I hear this back and forth about what the law says, but I do know for a fact that our citizens got to be involved in anything that you guys are building out here. If our citizens are not involved with it, and I heard Mr. Hilliard say, as a courtesy, he spoke with the council person. I personally don't think that's a courtesy. I think it should be more of you should have to speak to that council person, because that council person is being held to the fire by the constituents and the people in that area. Those are the people voted her in office. And if she go and make a decision or don't try to fight for what those people want, they should vote her out of office. So I can respect her for respecting that neighborhood, because if I want to develop something, go build it in Alpharetta, Johns Creek, I'm not going to go up there and do it unless those people in that immediate area accept it and approve it, so to speak, however they want to do it. So, I hear him say that you guys are one of the largest developers in the nation. You spent $973,000. But before you would have done that, it seemed like to me you guys at least would have considered or got some solid buy-in, or at least good consensus on the record from those immediate neighbors. I'm not doubting that some people might have wanted it, but I can tell you where I live at, I really don't prefer a renter next door to me. I was a renter once too, but I just think that they need to be considered. It's a place for all of that. It is a place. We need more renting opportunities here. But every one of those people that I saw speak tonight, and I think he made a reference to 323 homes, none of those, however many homes it is, if it's 200 homes there, at least, I think y'all probably should have brought one of them guys here. Have somebody here to say, hey, I want this. But those are homeowners that sat on that back row, and they were pretty serious about making a point known that they do not want a renter right next door to them. That's what I heard. I'm a builder-friendly guy, believe it or not. I really am. I am a straight builder-friendly guy and think stuff should be brought here. But when you got neighbors saying that they don't want something, I think, me personally, I respect that. I respect that bigger than anything that's written on paper. If it's supposed to be some commercial, I hear everybody throughout this whole election cycle went through, they want nice amenities, they want a certain level type of restaurant, they getting tired of the regular Popeyes and your Church's Chicken, they want something meaningful brought to the neighborhood. If you guys were promoting something like that to go along with this mixed use development, I think the road would be a little bit easier. Because if those people back there who came in had been in favor of what you guys are doing, I would tell you right now, you would probably get my vote. But right now, I got a real problem with supporting what you all are doing without the community involvement. That's just where I'm at. And that's no matter who it offends, who it upsets. And I don't live in that particular District 1. I live in a different district. But I respect what those people want in their district. That's where I'm at. I'm looking at this letter y'all keep referring back to, and I see here on the third paragraph, second sentence, where it says, therefore, or thereafter, subject to the presentation of a site plan with 200 multifamily units to the Department of Community Development, as well as demonstrated compliance with all other conditions, whatever the other conditions may be, of zoning associated with the subject property, our office will confirm the subject zoning requirement has been satisfied. That tells me there that to me, and I'm not the brightest guy, on earth, but this tells me that somebody still trying to make a decision based on, like, if something else needed to be met here. And if I'm interpreting it wrong, I see you shaking your head, Mr. Hilliard. If you don't mind, would you please expound on that, please?
So the letter was written, a confirmation was sent back about what the entitlements were. And then the other conditions were complied with through the process.
Yes, sir.
We did all of that. There weren't any other conditions we were asked to satisfy. In fact, the only issue that they've been talking about all night is a condition that was associated with the property at the outset, whether
Right.
the concept plan is something that you have to comply with or not. So I'll let Ray tell you more about that so we can answer that question fully, because
Yes,
I want to
sir.
make sure you're clear about that.
No
The
problem.
code and a part of the process was a pre-conceptual meeting with all the departments. We did that. We talked about the zoning conditions. We did that in a pre-development meeting. So the letter, we understood that there was still work to do.
Yes,
Right?
that's
There
what I'm
was.
understanding. There's work to
There
do.
was, and we did. What the problem is that site plan there is, you can read it in that zoning, it says it is conceptual only. That's what it says, conceptual only. Through the process, no one ever told us that, hey, you have to meet this zoning condition, which is a site plan. You got to put those buildings exactly where they are. That was never told us, never written, never verbally told to us, and I don't think anybody would argue that. That's the problem. We went forward.
So another thing in zoning 101, I'm familiar with, that you need community buy-in too.
Sure.
Did you all present that to the city?
We presented to,
Let me correct him. Community, so there's a difference between a property that's going through the rezoning process and one that is entitled as of right. If it's entitled as of right, the only thing a developer is required to do is to go to the city and get the permits. Now, whether you think it's good form, and I think it is good form sometimes to go to the community as a courtesy, but when it's property that's zoned as of right, there is no requirement to go to the community to get buy-in. And I say that respectfully because I understand what you're saying, because particularly in South Fulton with all the new development coming, people want to know what's coming, they want to have some input in it. But
Yeah.
if you're rezoning it, there's this whole process. The city has a public participation plan. You have to go to all these public hearings for as of right. That is not a requirement. And I don't think the applicant or this developer or any developer that's developing property as of right and is not talking to the community about it as a result should be punished in the zoning process because of that.
Yeah, okay. All due respect, I don't look at it as being a punishment though, because what I'm looking at it is this here. I hear y'all speaking about something from 24 years ago. And most of us here have been in this city probably 30 to 40 years, way before we become a city. We respect that. But the problem we've gotten here is a lot of people here have been making decisions that they're not even either construction-minded people or they have not considered neighbors. Now, some of the issues we got in that exact same area is infrastructure. It's infrastructure. People that can't even get home back and forth there. There's a lot of changes that have taken place in the last since 2001, 24 years. Now, between congestedness, traffic control, all of that, I think if you guys had went and spoke with that particular community and that gentleman Barnes, who is the HOA president of that particular community, and just explain what are you guys willing to do as far as amenities for number one. I heard Crocker say that there's room for that. And whether the master developer get bent out of shape or not, he need to understand that we don't care about him getting bent out of shape. What those neighbors and people care about is they gotta live there. They're gonna be there for the next 40 to 50, they're gonna raise their families there. So getting bent out of shape or not, they just want something there, quality, and the way, but they got a serious congestion problem as far as getting in and out for infrastructure. Have y'all spoken to any of that? Because I hadn't heard anything about it.
Yeah, I think, let me clarify. I think you and we agree with you that the community should have a role and an understanding of
Yes,
what's
sir.
going on and have some input. We don't disagree with that. When I was describing zoning as of right across the nation,
Yes, sir.
developers develop property. If they
Understood.
can do it, they're not asking for permission from the community. That's just how it goes, right?
get it.
And so, but it's not for out of disregard for that, for interests of the community. They're going to develop the property as they develop it, and you all have a right to have some input into it. So I don't want to make sure you understand. I don't disagree with you on that point. But the issue that you're deciding here tonight, you know, what we're asking you to say is if the decision that the city said it made and the basis that they said they made the decision, was it erroneous or not? It's an unrelated to decision to whether we're building what you want to see. And I say that as respectfully as I can so that we make sure that you understand
Right.
if you make the decision because we didn't talk to the neighbor, you don't like the design of what we're doing and all those things, those are things that are outside of the review before you tonight and won't be considered if it has to be challenged in some way. But we do want to talk to you about that separately.
I hear what you're saying. I've heard that at least 4 or 5 times a night, saying that it would end up in court. And in my personal opinion, that's where it need to be. Because, and the reason I'm saying it need to be there, because if you take the citizens out of this conversation, I could not in my good conscience make a decision against those neighbors who was here speaking. And I hear other people sit here and make decisions about something that's not right next door to them. I mean, I wouldn't do anything to my neighbor that I wouldn't want my neighbor doing unto me. We got a problem here in the city of South Fulton with Union City doing stuff on the border that's next to us that we can't do anything about. But here within this city, we can. And 200 more homes in that particular area. And I'm just looking at this letter though. Maybe I'm interpreting it different than you. I'm kind of interpreting it the way McClendon, Matt, Paul, and y'all have to forgive me for calling your names like I'm calling because hey, hey. But anyway, you know, that's how I'm interpreting it, kind of like they're interpreting it. And I think this may be something going, you know, that may need to be in court. I don't know how these guys going to vote, but as of right now, I truly cannot vote yes to this. And I would, after it's done, I would like to make a motion that's flat out denied. So I'm done.
May I be heard just to
Yes, sir.
expound on this a little bit? So I want to reframe the response somewhat because there is a remedy to citizens and people who want to be heard and they want to have their input.
Yes, sir.
Going to a council member to have them stop a lawfully zoned and pre-planned project isn't the answer. What the answer respectfully is, go to your council member and change the zoning. Make this site plan specific so it does have to be adhered to strictly. But don't punish a good faith developer who's trying to add value to the community, who is following all the existing rules. Go to your council member, have them change the zoning rules so that they are consistent with what you envision and what the gentleman who spoke envisions, that don't allow, as it currently exists, this zoning as of right. So it's not that we are trying to cut anybody out at
Yes.
all. It's just denying this is not the right way to go about enacting the change that you want to see. It respectfully would be my answer.
Totally understood. What's your name?
Joe Siegelman.
Okay, all right, Joe Singleman, I hear what you're saying, and I can tell you this, and I'm gonna, after I say this, I'm gonna let the chairman pass it on to the next person. Our council right now is in a very, I'm talking about the entire council, including this newly elected mayor. They're in a very tough spot right now, and when you speak about rezoning right now, we watching them so close, we watching them like a hawk right now. Anything you do on that council, when it comes to this property and rezoning, you will be held accountable. I'm personally going to be doing it, but I know quite a few people are watching them. So that may be easier said than done. But right now, with this case here in particular, I just think the citizens need to be respected. That's it. I think you guys probably truthfully can get this done a whole lot easier by having a conversation with that neighborhood and with the respected council person over that district. I think that's probably a better route. Now, if you guys want to defer something, I hear it. But me personally, if I'm the deciding vote tonight, you're gonna lose with me, and you're gonna find yourself in court as if Mr. Hilliard say, and that's it. If I'm the deciding vote.
And I gave my answer, understanding that we were not likely to change your opinion. I just wanted you to know that there is a way to tackle what you're after that's not denying a rightfully, zoned
Yes, sir.
property.
Respectfully taken.
Okay, hang on one second. The chair only votes in the event of a tie. So ideally, I won't be voting tonight, and I typically don't even weigh in, but I respect what everybody's had to say. In America, we have something called property rights. And if I buy a piece of property, knowing what it's zoned, and if it's zoned multifamily, then I have the right to build multifamily if my neighbor don't like it and says, hey, I don't want any apartments going here. My neighbor has a right to buy that property from me, but my neighbor can't tell me what to do with my property that's lawfully zoned multifamily. If we're hung up on design, that's one thing, but if we are hung up on the fact that people are gonna be renting these units, well, duh, that's what multifamily means by nature. And so having said that, Mr. O'Donnell,
All right, hear me out here. There's gonna be a lot of questions that I just would like to have answered, and honestly, yep, sorry, thank you. I got a lot of questions here, so that I've got clarification. Because I'm in a complete agreement with you on that. You know, property owners do have rights. Owners do have rights, and my understanding. That's red.
No, it's on.
Sorry.
It's on.
Let me get a little bit closer in the mouth. So property owners do have rights and so forth. I just want to make sure to see if everybody agrees on this, on a couple of these. We are bound originally by the 2001 zoning agreement, correct? Do you agree with that?
Yes.
With the amendments made in 2004, is that correct?
We have not seen 2004 amendments.
If they have been legally filed, are you still bound by the agreement or the amendments in 2004?
If they were legally filed.
Yeah, if there's a zoning decision that was lawfully occurred and
Okay.
on the record,
All right,
yes.
thank you. That's all I need to know. I'm good. Thank you very much.
May I answer the question now? Because you asked.
Well, I'm just wondering if they agree with that statement.
Okay.
We would only kind of clarify that 2004 zoning doesn't apply to the whole property. It doesn't apply to the property in question tonight either.
I agree with you, to an extent. The property that you've purchased, have you purchased, or are you potentially purchasing all of F, E, and D, or just a portion of F and E?
Just a portion of.
I can't tell where the property lines are here. I believe E is an existing property. I believe it is all in F.
It is all,
I can't
just a
tell
correction,
exactly.
it's all in F. But you will say that you agree, you'll state that your development that you're proposing is currently in F. Is that an agreed assumption?
I would say the majority of it is in F until I see property lines I
Okay.
can't tell.
Thank you. Now, going back to the original 2001, it states here that you can build the 550 home, multifamily homes. And in your opening statement, you said there was 220 lots, but then since I've heard 200 here, and you've also stated 200. So I just would like to know how many lots you have, or pardon me,
There's one lot, there's one parcel. This is a multifamily development.
I'm sorry.
Individual units.
That's what I mean. My apologies.
200 units,
So you agree that there's 200 units remaining?
yes.
Okay, I just want to make sure because, like I said, very beginning, you said 220. Okay? Now, looking at this, would you, hold on. Show me where you say it's conceptual.
Just point us to the page. Just tell us the page number. From the podium, from the podium, from the podium, from the podium. Everything into the mic.
10-2. Exhibit C, which is the original zoning, flip to the 5th or the 6th page. Top of the page, 2A, says,
Okay?
said site plan is conceptual only and must
Gotcha,
meet
thank
or
you.
exceed the requirements of the zoning
Okay.
resolution.
Now, hold on.
Can you say that again, where it is? I didn't find it.
Under C, tab C,
Hold on. I've lost my track here.
we do not.
So, in the modifications in 2004, it states,
We didn't know it.
in 2004, it shows out that the approved zoning plan is District A and B, is 150 plus 75, 225 units, all single family. The revised single family phase 1, 2, and 4 is 207. 2 townhomes are entitled to go into District C and District E. 50 plus 50, 100 units. Phase 3, 98 units of townhomes. Luxury apartments, which is where we're at, District D, 350. Are you building your home, your units in District D, or are you in F and E?
F.
F. So,
Majority is in F, like I said.
okay,
It was,
now,
350 units were built by the slate.
right,
It is in place today, correct?
now there's a site plan for here from 2004. Stand by. If I had gotten this ahead of time, I would have been more prepared. My apologies.
Just take your time and relax. We're already here. Take your time. You got the floor.
It's in here. All these names. What's that? See, my understanding is you do have rights to build the units. I don't really care for it. I'm going to be blunt. Okay? You stated earlier that you want to partner with the city of South Fulton in the future. Right now, with what you're doing, you haven't matched the needs or the desires of what the city of South Fulton really wants. Now, I think you have the potential to win the battle, but are you willing to lose the war in partnering with the city of South Fulton in the long run? Do you really want to be that company? And, you know, if you give me a half a minute here or a couple of minutes, I believe that in the 2004 update, there is no modifications, it's stated, to section F, and it describes it as a city center. And if you're building your condo or your units in portion of F, I don't think that meets the modification in 2004. It doesn't matter whether you want to follow that footprint, but would you call what you're building a city center?
It's a multifamily community.
It's a multifamily community, but it's not a city center.
Typically not.
Okay. I mean, if you want to give me 5 minutes of, you know, like I said, I'm trying to hurry here, but I read it in here while they were talking.
So the zoning modification that happened in 2004
Yep.
referenced when the multifamily, 350 multifamily unit parcels were purchased, they went through a zoning modification to modify the plan to allow their proposed development to be built, is what you're reviewing. Is that what I'm understanding?
That is correct.
Okay.
But there's also, it states there are to be no changes to Pod F.
Okay.
Here we go. Take a look at this, if you don't mind. This is from the map. Would you say that this is a conceptual?
We haven't seen it. Yeah.
Would you I'm asking you, would you call this a conceptual plan, or would you say that that's actually drawn out by an architect or a full development plan?
Let's say this is a conceptual plan.
Behind the mic, please.
My opinion, this is a conceptual plan. There are no parking lines drawn. I mean, you mean, you know the difference between a conceptual plan and a fully designed plan. It's not a full.
And also, it's not just the plan is included with the file. Does this condition of zoning say that this is a condition of the zoning? That this site plan is a condition of the zoning? And we don't have the benefit of the file that you're looking at. We're just answering
Well,
your
hey,
questions.
you know,
based on
unfortunately,
your-
I didn't either until, you know, I demanded it and people were actually
You're
irritated
gonna say that, right?
that gave it
Sure,
to me.
I think we know that. Yeah, I think we know that. You don't need to
And
say it.
to be blunt with you, I was unfortunately in support, unwillingly, with your position. I really was. But this modification, I think, is a technicality that you don't meet the needs. You don't meet the requirements. That's my opinion. And we can go through this and take some time and truly look at it. I would encourage my panel members to actually look and read the documents in the modification before you make a decision, because we are looking at $1 million lawsuit if we make the wrong decision.
I fully agree with that.
I'll table.
Ms. Faraday?
I agree, to an extent. I have a comment, and the developers might want to respond, and the city might want to respond as well. The developers are saying that steps was followed and taken, several meetings, several documents, was met and required. I unfortunately, I haven't read this information either. And I'm just receiving your information as well. But from my understanding, just hearing both sides speak, the developers are saying, hey, we followed the rules, we followed the steps, and it was a conceptual plan. They showed us where it was a conceptual plan and not a set in stone site plan. As far as legality goes, what you guys are saying. So I want to make it, I want to be clear that we are voting, the whole board is voting on the same thing. I think we all have our different way of thinking what we're voting on. So I don't know who should answer this question, but what are we voting on? Because there's a lot of information in here, and I'm pretty sure we can find a lot of hiccups in this, as well as we can find a lot of hiccups in this. So we need to be clear as a board what we're voting on, and if we're going to make a good decision based on what we're voting on. I think that's a fair question, because I'm pretty clear on everybody's questions that we don't know what we're voting on. I think I know what I'm voting on, but I don't think we know what we're voting on right now. I just don't think we know what we're voting on right now. I think it's going all over the place. So who want to make that clear? My question is to make it clear to the board what we are voting on.
I think that's already.
No, it's not, because we got down at the end, someone saying that we're voting on.
Hold on, please, respectfully. Each board member has questions, and each board member has an opinion and a narrative. So it's your floor right now, Ms. Faraday. If you have any questions, please ask those questions.
Sure.
Once everybody
What are
on
we
the
voting
board
on?
has finished asking their questions, as I normally do, I will open the floor for any motions. And then you guys are perfectly free to make the motion that best suits your mood.
Okay. What are we voting on?
Yes. We're going to pull up the slide. So, under City of South Fulton Code Section 5-6009F, it explains the standard that this Zoning Board of Appeals is to adhere to. The highlighted section, an appeal shall be sustained only upon an expressed finding by the board that the administrative official's action was based on an erroneous finding of a material fact, or that the administrative official acted in an arbitrary manner. The appeal that's before this board is an appeal filed by the developer of an action taken by Ms. Karen Dominy, a city staff member. And if we can flip just a couple of slides forward. Again, right here. And so this is the statement that's at issue. So the developer, under the city's code, has 30 days to file an appeal of a decision that they take issue with. So this is, in their determination, the decision that they have challenged. And it says by Ms. Karen Dominy, this development does not match what was approved in the site plan for zoning petition 2001Z0079. The zoning case has this area designated as Pod F, which is a town center that contains community services, commercial components, and residential components that contain loft apartments, townhomes, and an assisted living facility. So if you look at the standard under the city code, and then you overlay that with this statement by Ms. Dominy, the question before the board is, did she make a mistake, a material fact? Did she do something that was arbitrary?
Stay there for a second. There is specific language in some of these documents that a specific council member intervened. Can you speak to that?
I don't know anything more than what I've heard this evening.
If you were to learn that were true, would that by definition start to enter into that territory where we call arbitrary?
No, because that's not the subject of this appeal. If that council member's action was the subject of the appeal, then the question would be, was that council member's action arbitrary? The subject of the appeal is chosen by the appellant, not by the city.
All right, another question. we're having some discrepancy as to whether or not this was site-specific or conceptual. I've got a alcohol permit out in DeKalb County for a business that I own, and I had to submit a very specific site plan, parking laid out, everything from number of chairs inside. So I know what a site plan looks like when it's supposed to be specific. Are you saying that that's this?
No.
Okay.
No,
What are you saying?
that is a different level of site plan when it comes time for permitting.
Okay, so where are we hung up here? Because it sounds like you're saying that this is beyond conceptual, and they're saying, no, this was conceptual, and that is what was submitted and approved.
For the purposes of the Zoning Board of Appeals, I would say even if this is merely conceptual, I think that the important thing here is that the appellant is here tonight saying that they can build 200 apartments as of right. Where do they claim that right comes from? From the site plan. And so it's the same site plan, it's the same zoning decision. And the zoning decision has a conceptual site plan. And Ms. Tomini, in her determination, this wasn't close enough to that site plan to merit going forward with the determination of whether or not to grant a permit.
I have a question.
Ms. Jerome. Oh, I'm sorry, Ms. Evans, I apologize. I just heard a voice down
No
there.
problem, no problem. So to clarify, from my understanding what you're saying, so Ms. Tomini, when she looked at the application, so previously it had been approved, based on what they had submitted, and it was, it matched what was being approved. But when she looked at that last date where she denied it, that was where she felt it was not matching, what they were asking for. So that was what was happening, right? Am I following?
My
all of that?
understanding is that in the approval process, again, there was not a final approval that was made, but in Ms. Tomini's review and in staff review, when they were initially thinking that this would comply, the focus was on the number of apartments and things such as that.
And the thing that she noticed, as not applying was there were no lot apartments, no townhomes or assisted living facilities. Is that what I'm reading? And the community services, so that was lacking. And so this last conceptual, what is it? Site plan that they submitted, it only contained the 200 townhome units.
200 apartments.
The 200 apartments, okay. All right, so, but they do have the right, because it was zoned multifamily, so they do have that right to build the apartments, the 200 apartments.
Well,
If it adheres with,
the decision that Director McClendon made was that in this entire plan, 200 more apartments could be built. And as far as whether 200 apartments could be built on the property, on that portion of Pod F that Quarterra filed the permit for, the city has taken the position that no. Even if you can build 200 apartments, you can't do it like that. You can't concentrate it like that.
so it has to be the 200 with the additional community services added on.
Right, well, it really, the governing site plan, even if as a concept, is the Pod F site plan that was approved back in 2001. If you want to vary dramatically from that, then you need to come for a rezoning.
So where in the file was the initial submission? What was the variance?
I'm sorry, from Quarterra?
From Quarterra, yeah.
I know that there's a reference to, I think, like maybe a March
You had-
2024 or May
You
2024
had
letter.
Yes.
another submission?
So go back to the process. So we met with the city in We got the letter in July of '24. We met with the city on their required pre-conceptual plan meeting. We put our conceptual plan on the table. We met with them and talked about it. We showed it to them on the screen. Excuse me, I believe it was a Zoom meeting. We showed it to them on the screen. We had the 2001 zoning file. Everyone had all the information. We walked away understanding our plan was approved to progress it. We progressed it to the next meeting, Taylor, and that was the pre-development meeting a month or two later. Progressed the plan further, met with all the departments. We met the zoning conditions, and we showed a site plan, as Reginald's letter says, that shows 200 multifamily units, and we proceeded to permit. We submitted our plans for permit. They were accepted by the city, multiple rounds of review, and then approval.
So basically, if you don't develop here, another apartment community can be developed here
Well,
of lower quality.
I'll tell you this, I understand multifamily and I understand commercial development. This site has been zoned with that plan for over 25 years, and this market has not brought in a mixed-use development, and it probably won't for another 25 years. If that's what the city wants to have built here, it's gonna be very difficult. The market decides what happens in certain areas.
Okay, thank you so much.
Mr. Roan.
Thank you. So I just want to make sure that I'm following, and I know everybody's trying to make sure that they hone in on what they want to know. But for the purpose of understanding the vote for tonight, the affidavit of Taylor Harper that's up right now, do you concur that that is the issue that needs to be voted on?
The issue that needs to be voted on is a denial of our plat and our civil plans after we've been through the process as is typically done.
I'll just add, I think the issue before you this evening is whether this comment by Ms. Tomini is no different than the argument that the city attorney has been making on a separate point. They're making the same point. The concept plan governs this project. He's saying it because the overall site plan is not consistent. She's saying, I don't see all the things that are on the site plan. We're very comfortable with that argument. We'd like you to rule in our favor so we don't have to deal with it any further. But we're very comfortable if you all decide that this site plan is why this decision was made. You know, when you say what we were appealing, when this decision happened, we learned that there was a problem because Councilmember Rao pulled this from the agenda. And when we contacted her, my client contacted her, she said, contact Reginald McClendon for an understanding. And we've, to this date, that was in September. I think we're in December. We've never been able to have a conversation about it. So we don't know. And so we went and found this comment when we were trying to search for the reason, and that's what was in the file. So, okay, we guess they must have designed it based on zoning. We tried to have a conversation. We talked to Matthew Williams and Ms. Tomini. They started giving us some more context about what was told to them about why it happened, and we said we needed to preserve our rights. So we waited from the date of this note from September the 3rd until October the 3rd. Because you have to file an appeal of an administrative decision within 30 days, and we got no answer, so we filed an appeal to preserve our rights to be here. Because if we hadn't, and we brought it down, then the argument would be different. Well, they ran out of time. This is a shell game.
So this is not what was in your appeal?
No, this issue was in our appeal.
Okay.
What we interpret this decision as is the same thing that the city attorney's been arguing all night.
Okay.
That the concept plan is not a concept plan. You don't believe what it says on the paper. Believe what I tell you it means.
Okay,
That's what he's arguing, and that's what this argues.
I want to make sure I understand where we do have some concurrence.
Right.
Please, if you want to add to.
I want to clarify that it's been stated that what you're voting on is the denial of the plat. And I want to clarify that that is not what you're voting on, because the plat is not, first of all, the denial of the plat or the approval of the plat is a decision for the council. Our board doesn't have authority over that. It's a decision for the council, and it has not been denied, it hasn't been voted on. So we're not voting on that tonight. because that's a legislative decision for the council that has not been voted on.
Okay, I have some additional questions for the city, so whoever wants to answer. Is it discretionary or mandatory, right? I'm gonna say this again. Is it discretionary or mandatory that a deviation from a conceptual site plan be cured by rezoning?
If I understand your question, there is a matter of, there's at least some degree of discretion.
Okay, so would the appellant's plan be able to move forward if somebody agreed with them and said, go ahead? That would be okay in a discretionary capacity and not affect any laws?
Is your question, would a staff member have the discretion to have approved?
Yes.
And again, this wasn't approval or denial of the permit itself, but to have said that this can move forward to the council vote?
Yes.
That's a good question. I think that's really pushing the bounds. I mean, that'd be an unbridled discretion, but you know, certainly when you're looking at, for the purposes of this question, looking at a conceptual site plan, there is a degree of discretion that is involved in making that decision. And sometimes when someone disagrees with that discretion, we end up in an appeal like this.
Okay. Mr. O'Donnell made a reference to the changes that were made in 2004. What, if any, relevance does that have to this?
So 2004 locks in that 2001 Pod F site plan. So it specifically accepted the Pod F site plan. I mean, there's more to it than that. It's a lengthy document, but for our purposes tonight, you know, what we've been looking at and what city staff has looked at is what was originally adopted in 2001 by Fulton County, and then what changes, if any, were made in 2004 for this particular part of the property.
Okay. And so, again, my questions are clarifying questions to be clear. What the appellant can do that the city would agree with is to fill out an application for rezoning. Yes?
That is one thing that the appellant could do, yes.
What else can they do?
Well, they could also submit a site plan they could also submit a permit to develop the property in accordance to the 2001 site plan, or something substantially similar. There is some amount of discretion. It's not unbridled, but there is some amount.
Okay. Mr. Crocker made a, no, you can stay there, made a suggestion that another developer could come in essentially and they could come in with commercial development, right? So the information that I read in Exhibit B, it's an email that references, as Ms. Evans spoke about a few minutes ago, what the original conceptual plan required or stated that it would have, which was community services, commercial components, and residential components that contain loft apartments, townhomes, and assisted living facility. The apartments that they want to build, do they meet the loft apartment criteria?
I'm not sure. I know in Pod F, there it does show this mixture of uses.
Is it completely off base, or are they meeting a portion of the conceptual plan from 2001?
I think that, well, it's kind of hard to answer for a couple reasons. One reason is Pod F is a much larger property than this site plan. And so to say that Pod F has apartments and the site plan has apartments, in that sense, yes, there is overlap, but there's not much.
Okay, so if another developer was to come in, let's say they got green lighted, hypothetically, they built the 200 units, is there additional room to come in and complete the additional portions of the site plan so that the 2001 conceptual plan is preserved? Because from what I understood, the 200 units is not going to exhaust all of the available land. There are going to be multiple acres left over. So and obviously there have been multiple developers already. So if this developer comes in and is meeting a portion of the site plan and building loft apartments, can someone else come in and build the commercial components, the residential components, like the townhomes, the assisted living facility, to preserve the 2001 site plan so that it is met?
Not under what's been currently proposed. Now, would it be possible for a group of developers to come in and one developer says, we're doing the apartments, another one says, we're doing the town center, another one says, we're doing the assisted living? That's possible. And if a plan like that came before the city, then that would be a different consideration. But even in this case, you know, the developer can't say, well, we'll take all the apartments and we'll just wait to see if someone else does the rest of it. That's where the city staff has stepped in and said, no, that doesn't meet, even if it's just a concept plan, it doesn't meet the concept plan.
So then how did the initial units get built? If the initial plan was for 550 and there's still 200 left all these years later, how was there a break between the first developer and now these developers coming in? Because essentially, wouldn't they be able to do the same thing? Another developer could come in and build another piece.
That's an excellent question, and that really gets to the essence of this entire process. So what has happened historically for this property is that these, again, the property has a concept plan that fits the entire property. It's labeled all these different pods. Tonight we've been talking about a portion of Pod F, but these different pods, they came in, there were a couple of them, and I misspoke earlier when I said the Pod C had been developed as shown. That was inaccurate. But pods A, if I remember correctly, A and B, the ones that are on the south, were developed in that manner. And then in 2004, you had some subsequent development. So the short answer is the way that that's handled from the planning department perspective is by breaking it into pods, considering it on a pod by pod basis. And the development thus far has matched those pod by pod plans. Now we're on Pod F. The city has received a plan that does not match the Pod F plan. And so your question about how much discretion do they have? Well, the staff has enough discretion to say, this isn't close enough. How close do you have to get it? Much closer than this.
So Pod F needs to include all of the elements that the 2001 site plan says that Pod F needs to have to include the modifications from 2004. It's because they chose Pod F, basically, that they need to do what Pod F essentially calls for per the site plan.
That's correct. Or seek a rezoning.
Or seek the rezoning. Okay, so is the rezoning meant to circumvent the site plan to where they can only build the 200 units? What happens when they rezone? They rezone, build the 200 units, and then what?
Rezoning is a blank slate. It's that they file an application for what they want. It's considered by staff. Staff gives their recommendation. It goes through the planning process, ultimately voted on by the council.
Okay, but it's zone multifamily, and you would like for them to move forward with only the 200 units, right, that they propose to build, to rezone it as what? What would the rezoning be? Because it's zone multifamily, so what would they rezone to?
Well, it's zoned for mixed use.
It's zoned for mixed use.
Correct.
I think that's the
So-
first time I'm hearing that tonight.
Okay, it's zoned for mixed use. One of those uses is multifamily.
Oh, got it. Okay,
Yes.
okay. My other question is, at what point would, in your opinion, it would have been reasonable to, because part of the gripe is that they spent money, spent time, had multiple meetings, spoke with all the people, did all the things, and now a year later, almost $1 million in, they're like, oh yeah, by the way, right, you haven't met the site plan criteria. At what point would it have been reasonable, or at what point is it typically discussed, right? Once you review a concept plan, because they've had conceptual plan meetings, right? I think I saw at least 2 that you say your concept or your plan does not meet what is required for this. When would it have been reasonable to discuss that with the appellant? At what
Well,
point?
I can't say a specific date, but what I
Not
can.
not a date, but like at what
what
phase
point?
would it be? Typically at the first preconceptual meeting, second preconceptual meeting, or what department typically would tell you it's not what we need? Is it reasonable to have reached that conclusion before now, or before when they were informed?
That's a very good question. It's a fair question that I don't have the answer for. I mean, I know that the timeline is addressed in your materials. I will say that there was at one point a focus from the city's perspective on trying to determine whether these proposed units were going to be for sale. You know, if these were going to be owner-owned units or if they were going to be rental apartments. So I think that some of this, the delay occurred because of that, because we were focused, the city staff was focused on a question that ultimately was not an issue for the developer. The developer had already made a determination that these were going to be for rent.
I would like to address Ms. Jerome's question, and the question is about when would it have been reasonable to give them notice that they needed to meet this, site plan. And our position, the position of the city is that we gave them notice in 2024 with the letter from Director McClendon, because the letter says that they must meet all the requirements of the zoning. The zoning has been public record since 2001.
If I can clarify my question, they had meetings, and so I really wanted to know at what point in the process, after you've already started meeting, you're meeting face to face, you're on the phone, you're in communication, and they're reviewing your plan, to say to them, your plan does not match what we have, because the letters that were referenced and the public records is one thing, but now when you're actually doing business and you're speaking to a person and they're telling you that they've reviewed it and you're having pre-review site plan meetings, the appellant is saying that they were green lighted all the way. Sure, this is great, move forward. This looks good, move forward, right? So at what point, if something did not look right, would a staff member typically discover that? Because we are in a situation where we're deciding on whether or not there was something erroneous or arbitrary, and it's possibly erroneous, and that's what my questions are trying to sift through.
Okay, I can't answer to what time period, but I would say at any point when the staff member recognized that there was a problem. In these cases, so I would say where the errors were made were at any point where the green light was given, but where the zoning decision that we're focused on is the one that was the denial. That happened in September of 2025. That was not an error. So if there were any errors in the green light, those errors took place before that. But the decision on September 3rd, 2025 was not an error. So I would say if it had come to the staff's knowledge that they were not meeting the site plan, 6 months before, that would have been the time to tell them. And if we made an error there, we're responsible for that error, but that does not give them a vested right to continue.
Can I, don't go away quite yet. I do want to hear from you, Mr. McClendon. When you say, that you're responsible for the error, in what way?
In that we made the error. That's what I mean. We if we didn't tell them, but I can't say for certain that it was an error because I don't know all the information. I wasn't in those meetings with the staff, and I don't know all the information that was presented to the staff. I don't know if a full, what's been presented to you with all the apartments. I don't know if that was fully presented to the staff 6 months before September of 2025 or 9 months before. But I'm saying if it was, and we should have told them at that point in time that, hey, you're not meeting the 2001 zoning and you have to meet that, then we're responsible for that error. But that error that would have been made would be similar to what Attorney Hilliard said. If someone gave them a right to, someone told them in the city that you have a right to build a hotel out here, if that person made a mistake, that doesn't give them vested right to build a hotel out here.
Understood.
If the city made a mistake 9 months before or 3 months before September of 2025, that doesn't give them vested rights.
Right. Did Mr. McClendon want to add?
Thank you, Reggie McClendon, Managing Director of Community Development and Regulatory Affairs. Of course, I was hoping not to speak, but I do want to clarify one thing about our preconceptual and our pre-development meetings. It has been said that those meetings were mandatory. They are not mandatory. Our preconceptual and pre-development meetings are voluntary offerings that we give to developers. And the purpose of those meetings is that they come to us with questions that they might have. The preconceptual meetings are designed to be less formal and for people who are kind of just coming up with a concept. The pre-development meetings are really, they're designed to bring in quite a bit of city staff, our fire department, public works department, et cetera. And those are for developers who really have pointed questions about technical items that might come up in the development that we are going to want to give them advice on, either prior to or after they have already submitted development plans. Neither of those meetings actually involves a review from staff. Generally, how those meetings go is that we offer the meetings, the developers come in, and they ask us whatever they want to ask, and we answer those questions to the best of our ability. But what we don't do is we don't go through a thorough review of those projects prior to those meetings or after those meetings. We just answer the questions that they have. And so I just want to be clear that those meetings are not official. They're not required meetings, and they're not designed to give people approvals or disapprovals. They're just designed to help people along through the process.
Okay. I want to know how many acres are going to be used for the 200 units and how many would be left? Because the next thing I would want to know is if the city would be willing to reserve any land that's not used in Pod F for the future commercial development to meet the original site plan. But how many acres does your site plan take up, and how much land would be reserved?
We originally put under contract 73 acres, and the current site plan, I believe, Taylor, is 23 and change. So that leaves 50-something acres.
And the city,
Now,
would they be willing to?
Let me correct something here.
Yep.
In this master development, there were 11, I believe, acres outside the master development that was part of that 73. So 73 minus 11 is 62. Then we were on 62 would be remaining in the master development. We took 23. Yeah, that's rough numbers, so there's somewhere around 40-something acres.
I would like to clarify your question. The second part of your question, would the city be willing to reserve the remainder?
So if the appellant was green lighted with conditions, let's say, right? You can build your 200 units on however many acres he said he needs, and the remainder, as long as the remainder is reserved for essentially the completion of the 2001 site plan. Nothing else can be used, nothing else can be built on that land unless it is going to be used for the commercial components of the 2001 site plan, the townhomes, the assisted living facility, or anything else that was part of the 2001 site plan. Would that be feasible?
I would say that would be a question for the council,
Okay.
so they would have to make that decision.
And my last question is, how much would it cost the appellant to go through the rezoning process?
I think with the current site plan being approved, let's assume that, which sounds like would be very difficult, it would probably cost us around $50,000. With a site plan change requiring commercial and everything within our multifamily, that would be basically throwing away all of our design that has been approved up to this point. I call it approved, reviewed with no rebuttal until the very end. It would be the total that we've spent to date, which is $973,000.
No further questions. Thank you.
And I would just like to clarify on the reasonable time to tell us that the site plan didn't meet it. We emailed Karen Tomini on July 12th of '24, asking what the site plan approval process was, and she said that there was none. It's in Exhibit C.2.
All right, I think we've got just a, hang on a second.
Still got the hand up, Jim.
Hold on a second. Is there, and this is for the city and the applicant, before I open the floor for any motions, do you guys think there's any room? As I'm saying this, I'm aware that in your opinion, there's been an absolute lack of response to your inquiries. That aside, is there any possibility before I open the floor for a motion to resolve this in a way that I want to say both sides, but probably that wouldn't be right terminology because the city's not going to give any ground, but well, they may, in a way where both sides might give a little ground to, and even as I say this, my own personal opinion is that it was not a required site-specific plan. But having said that, I just wonder if there's any room for you guys to come closer to what the city may suggest as being closer to what was originally submitted, although I wouldn't say that it has to be identical because
I think
hang on one second. Hanging on what you just said, in her questioning, you use a phrase that the plan would be much closer. You recall that answer to her inquiry about the plan? You said it would be much closer. that's very subjective language. Much closer in whose mind, the city council person, the staff, or who. So I'm just I'm a little leery about that kind of language. It just sounds very subjective, and so before opening the floor to a motion that may cause all of us to stub our toe, I'm just wondering if there's any, both from the city and from the applicant, if there's any room for coming back to this, since, you guys have invested a lot of money here.
So I would address Mr. Mathis's question relating back to Ms. Jerome's question. Her question was about the amount of discretion that the city had. And anytime we're exercising discretion, there is subjectivity. So, if we're looking at the concept of a plan and we're exercising discretion, we have to exercise discretion. So it has to be some subjectivity. Otherwise, we would default back to the letter of the law. So if we were exercising discretion, we're not relying on the letter of the law, we're relying on subjectivity. But the subjectivity would be based upon the expertise of the staff and using the conceptual site plan as a guide.
I just don't, and I guess I'm gonna talk a little bit more than I wanted to talk, but I just wouldn't want that discretion. And I know I ought not to go here, but I'm going anyway. I wouldn't want that discretion to look like the property is not already zoned in the fashion that it's zoned with respect to Council District 1. City of South Fulton doesn't have a Buckhead. And so if there can be apartments in District 7, there can be apartments in District 1, as long as it meets a satisfactory level of appearance for the city. And so I don't want to be hung up on that kind of subjectivity.
Okay, did you want a response from me on that?
Yeah, please.
The city is being, again, guided by the 2001 zoning. Our position is that the 2001 zoning is a law. There is some discretion, but the discretion is not wide, it's not arbitrary. There may be some discretion, but it's not unfettered discretion. So we're not arguing whether or not apartments can be built, because in the mixed use, apartments can be built based upon the current zoning. But the current zoning also has other conditions along with the allowance of apartments. It has other conditions. And our position is that we can't just ignore those other conditions because they're part of the law that was passed in 2001. So we don't have discretion to just ignore them.
No, I'm not suggesting that the discretion would be to ignore them. I'm suggesting that the discretion would be to apply them consistently, across the board.
Understood.
Can I ask you a question about the law?
Well, not me, I'm not an attorney, but you can ask an attorney a question about the law.
Well, my question is, we're talking about the law here. We keep talking about 2001. Is this 2004 agreement not valid?
It is valid.
So, okay, thank you. Let me ask you this then. In that, has any of you read that agreement? Because in it, it clearly states that the main, as far as it says where the roads are gonna be, the main circulation spine, and it also says clearly that Pod F is to be a multi-purpose, basically, retail area. And it has to have interconnectivity. It talks about green spaces in 2004. What they're providing There is no green space, number one, so it doesn't match this. There's no interconnectivity, and they're also developing into Pod F, which is clearly defined in 2004 as town center and commercial component of the plan. And that alone, I mean, there's your smoking gun. It sucks for you guys. I'm sorry. But if that's the law and we have to go by the current zoning, that's what it says.
The affidavit here says that residential components that contain loft apartments, townhomes, and assisted living facility. So somewhere somebody's already deviated from what you just read for 2004.
That's 2000.
And that's the purpose of this board. If you want to go by this, there'd be no need for us. So state your position,
Okay.
and then we're gonna move to the next person. Mr. Johnson,
All right, thank you for recognizing me. I'm gonna be
for
totally
the
honest.
second time.
Yeah, right, and I appreciate it, even though I heard some people speak 5 times on the other end, but I do want to say.
Mr. Johnson,
Go ahead.
I'm gonna take a point of privilege as chairman,
Okay, go ahead.
cause you're coming at me directly about not recognizing you. You say more words than most of our board members. I don't want to call you out about that, but
Go ahead and call me out.
I'm calling you out because
Okay.
you coming at me like I've ignored you, and I feel awkward that we're even doing this in front of the public. This is televised. In the 8 years I've been on this board, originally, we haven't had this kind of personal attention seeking. You know,
Call it what you like.
I'm not,
Because I've been patient over
Mr.
here.
Johnson, the chair is the chair.
Make your point.
The chair is the chair, Mr. Johnson. When you are acknowledged, that's when you speak, Mr. Johnson. There's a protocol.
Make your point, because I'm waiting to speak because I heard other people spoke without being acknowledged.
No, you haven't, because that's not what I do, and you know that. All right, at this time, I'm gonna take a motion from the board.
I would like to make a motion at this time to give us an opportunity to fully review all the documentation because the views have been so opposite from each side. And I want to make certain for my district that I'm really making a knowledgeable decision, not just based on what we're hearing here and the circular questions that's taking place tonight. I like to do my research. And that's a part of what I've always done as a doctor. I've done my research and I like to fully do my research. Some great points have been made this evening, but I want to make certain that my decision, not just based on the feelings of the community, the recommendations or discussions that have taken place with the council outside of me. I've not had those conversations, but I really want to look at the information myself from both sides and make a clear and honest decision. So I just wanted to, again, make a motion because there are some things and there are still a lot of questions that need to be answered because there are still some points that have been made from both sides that are really not clear. And timelines need to be really, I would like to see a full chronological from day one to now so I can really understand the dynamics completely. So I hate to be long-winded, but I would like to go ahead and make a motion if there is an opportunity for us to defer this so that the board can fully look at everything. Because this is a lot of information to try to digest in just this time frame. And I don't read and listen well collectively. I really need to go over this information. I've heard everything that everybody has had to say. Again, I appreciate the information, but that's just the motion I would like to make, to give us full knowledge where we really have some robust discussion and can knock this out one way or the other.
Make your motion specific to the next meeting or when?
I'm not certain, it's staff, is that a possibility to defer this?
Yes, under the provisions of our code, the board can take up to 60 days to make a decision. This is not in the code, but I would ask Attorney Hilliard if he would agree that the board can send questions to either side to be responded to, as long as both sides are privy to all the questions and the answers.
Right.
Would you agree to that?
In concept, I think we need to make sure we understand and have some clarity. Maybe if the board wants to ask questions of council, I think we can receive, we just need to coordinate it, just so that all the questions come by a certain date and then we all agree to respond at a certain time. So otherwise, we're lawyers, I want to see his response. Like, we're gonna be going back and forth, you're all gonna get 20 more, everybody's gonna weigh in. So if you can kind of, I don't know what you recommend, if their questions come within the next,
So then, within the 60 days, can I make a recommendation that would be inclusive of my motion that, as we're reviewing this documentation, if anybody has any specific questions on the board, we submit those questions to you all, say by Friday of every week, at the end of every week. And then you all possibly give us a response back by Monday or Tuesday of the following week. That would leave some order where we have a set time frame to get that in within the 60 days on a weekly basis, because this is a lot.
do you think it would be more efficient that if you all take a certain amount of time to get all your questions together, and then that way you don't have multiple
That would be
questions?
fine as well.
Everybody gets their questions back by a date
That-
certain.
Speaking to the mic,
That
I'm so
would be-
sorry. Speaking to the mic, sir.
I'm sorry?
She couldn't
Oh.
hear you. That would be fine as well, Attorney Hilliard. I was just trying to get that conversation started because y'all were kind of haggling a little bit there.
I'm answering.
So that would be fine as well. Just whatever works for you all, because I know that you all have other cases you all are dealing with, and we all have other lives. But I'm just trying to make it so that it's mutual for everybody. Everybody's questions get answered within a reasonable time, but we have to submit that information to you all in a reasonable time as well. So, we have the 60 days to review. However, I may have some questions in between that I may need answers to get clarity.
Can I say one thing? Well, one issue will be with the Open Meetings Act. And so we do want to make sure that the things that are supposed to be part of a public forum are part of the public forum. And so as you consider your motion, it might make sense to, whatever questions get submitted.
Just hold it.
Then it might make sense to hold them.
I thought
and
of
then
that as
perhaps
well.
come back in a public meeting.
Understood.
At a subsequent meeting.
Understood.
And I'll add to that, the other important reason is that any appeal that flows from these decisions is limited to the record. And we don't want to have a disagreement with the record. We've heard you all say multiple times this evening that the information that we submitted to the city as a part of our appeal back on October 3rd,
Right.
you all haven't received. And so it concerns us that the record is clear and complete. And because when things go to court, the lawyers start agreeing on what was in or out.
I just want to make sure that everything is above board and that we have a clear conscience on our decisions and are making a knowledgeable decision, not just based on what has been discussed in the past. I really want to review this documentation. So I'm making a motion to defer this case for 60 days. Staff, what would that date be? Is February? if that is a possibility, if we can split the 30, that would be great too. Staff, do we have the capability to split the 30?
To do what?
Split the 60 into a 30 and a 30?
Well, there's a regular scheduled meeting of this board for January, correct?
Correct.
So my proposal would be for the board to, assemble all your questions and then, for this item to be on the agenda for the
Correct.
January board meeting, just to answer those questions. And then you would have additional, whatever
30
is left of
days.
the 60 days
That,
to make a
that
decision.
sounds great. Okay, so let me make a motion to, defer this case for 60 days, but splitting that 60 day into a 30, with questions from the board, and the second 30 for responses from the appellate and our staff here and our attorneys.
Ms. Blackshear, is it okay if I make a suggestion?
Go ahead.
As far as, maybe a slight modification to the motion, having questions addressed in the January meeting and then having the February meeting.
As a
left for-
decision.
Yeah, as opposed to 60 days and figuring it out, just January.
That is, the 30 and the 30 is the 60.
Okay, I just wanted to make sure
Yeah.
that it didn't alter our regular meeting days.
No, the 30 and the 30 is going to happen, that's the 60, but it's gonna happen on our regular meeting day.
Okay, thank you so much.
I think,
That will be a part of, that's what's been recorded, so that will be a part of us. We should be getting that. If I'm correct, we will be getting your documents via electronically.
Yes, if I can just address a couple of things really
Please.
quick, and Attorney Hilliard and I just conferred. So we have both submitted documents in electronic format. We'll make
Okay.
sure that gets dispersed to everyone. So that is part of the record.
Right.
And one thing that the two of us are concerned with is that this zoning board of appeals makes its decision on the record. So in other words, correct.
Correct.
The record that we provide, so the things that are properly submitted before you. And so I'll just go ahead and say, and again, we've conferred about this, that whenever you do make your decision, whether it's tonight, I understand that there's a motion that sounds like it's about to be made.
Yes.
But whenever the decision is made, it needs to be made on the record and only on the record.
Correct.
And so that it's not subject to personal investigation or
Correct.
things like that.
yeah,
We
it's
fully
that-
agree.
You're like this is quasi judicial. You all are judges, so you can't go drive by the property and come back. Well, I've looked at this and this is what I think, because that's the natural tendency. Well, I want to see what's on the ground and see how this looks. But anything that happens, and we're not saying it because we're concerned about it, but because if the record is imperfect, the whole thing is upside down. We have to start over. And so we're really, by extending the hearing, you're really leaving the hearing open and leaving the record open. And we're really the ones that are supposed to be providing the record to you, and you're not supposed to go investigate your own information. Am I saying that
Well,
correctly, Counsel?
this is not from an investigative method for me. This is a
understand.
lot of paperwork,
No, I understand.
dialogue, communication.
I'm telling
So-
you what you're not thinking about, because it's
Yeah.
your inclination to go, okay, let's see what they're talking about. Let me go look at it. And then your opinion is formed based on something you see that everybody doesn't have the benefit of together.
Yeah, no, I'm looking at, and I would like the board as well, we're looking at the bigger picture, we're looking at the totality of everything, so, I guess I'll make a final motion, to wrap this up. We will, I make a motion to defer this 60 days, splitting the 60 into 30 in January, on the, our meeting day next month in January, which would be
January 15th.
January 15th of 2026, where we would ask our questions and we will review, and then the following 30 days,
February 19th.
February 19th, we will then make our decision on this case. And I think that's just fair across the board for everyone involved, since everybody's views are so different from both sides. I stand on that motion.
That was long. Tighten the motion up for me so somebody can second it.
Okay. I make a motion to do a 60-day deferral, 30-day questionnaire, 30-day decision on this case. There was no case number, so, on the emblem Sandtown. Is there anyone that was?
Motion's been made.
Sorry.
Point of clarification.
Yes, Ms. Patterson.
Thank you.
If there are questions, if I just want to correct the wording a little bit, Dr. Blackshear.
ahead.
If, it would probably be better if we just say to defer the discussion
next
till
meeting.
the next meeting, which is January 15th, because if the questions are asked and answered and a decision could be made on that day.
Right.
It may not require
It may
the
not
additional time.
require, but that
So
would
just
be.
defer it,
yeah.
and if you need to defer it,
Another 30, we will do that. Okay.
Was that your way of seconding?
second.
Thank you.
Motion has been made and second to defer this case to January 15th. All in favor say aye.
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 Any opposed, say nay. Hearing none. Motion has passed and this case is deferred until our January 15th meeting. Having said that, hope the parties are able to make it much easier for us when we come back in January. And everybody have a good Christmas and Happy New Year. I will entertain another motion at this time, the best motion.
Motion to adjourn.
Second.
Been properly moved and second to adjourn the meeting. All in favor, aye?
Aye. Me.
We are adjourned.